Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
We will
relevant.
bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dahil mihi Anglican po, he's verbal Latino.
Is that correct?
I didn't ask you to interrupt me.
Literally not true.
Oh, for crumb's sake.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict, and I'm up in the top corner. If you're looking for me, I was missing. I'll go back to where I belong. Just 1 second. Wow. All right. Welcome. Happy Friday. It is the weekend. It is upon us. And we have some fun stuff to do here. Let's see. First of all, Kim R., congratulations. You won the internet. Again. I think this is 4 in a row, Kim. If I might be 3, but I'm thinking it's 4 in a row for you, which is you're back in pro form. So congratulations on that, and good riddance as far as the internet goes. I'm glad you have to deal with it and not me. So standing only. I've got the seats turned on. Try one more time. Try this. Well, that's not working. Well, why would update is not available? It says. Update is not available. We're just going to bounce. We're just going to bounce the software just one time. I don't fault Lumia Stream on this one. I love Lumia Stream, what they do. It's really added a lot to the channel. They only charge $5 a month. For $5 a month, it can fail, 20% of the time, and I'd still be like, that's a good deal, right? I'm still on board. You still got me. That's still a success rate that I'm okay with as a customer. StreamYard, on the other hand, StreamYard for $90 a month, we need better quality out of StreamYard. There's a $6 a month plan that has 5 nines uptime. I wish. Upgrade me. All right. You can tell my voice that I'm not quite all the way better, but we're going to sing anyway. Why not? Why not? It's somebody's birthday and we have to celebrate it. Let's see. Duke it out to post birthdays. I'm totally distracted, says Red Pen. So let's see who wins on this one. I feel a sneeze coming on, which would be sneeze number 6 for the day. Let's see. Is chat on the screen? Oh, chat is back on the screen. Thank you, Greeners, for the reminder. I think I'm on the mend side of the cold, but even though I'm feeling better, I think I sound worse. I'm not sure why that happens that way, but usually, when you feel like crap and you don't quite look like crap yet, you have to explain to someone, I'm sorry, I'm not feeling well, and they're like, yeah, right, that's an excuse. But then, thanks Josh for this, appreciate it.
Happy birthday.
But
you
then,
look good.
Once you start feeling like crap, and you look like crap, everyone's like, oh, right, you're sick. And that's a little window when that happens. Then on the tail end, you look like crap, but you feel great, comparatively to how you were before. And everyone's like, I am so sorry. And you're like, why? I'm better. I'm better now. I'm in that stage. I'm in the better stage now, just for your information. All right. Motion for a sneeze counter, says JMR. All right. We're going to sing happy birthday to Alex, Sinbad, Elijah, Kristen, and Quelek. Nailed the pronunciation. First try. All right, everyone, wherever you are, stand up, take a deep breath, shoulders back, project your voice to the back of the room, and blend your voice with your neighbor to cover up my voice. Warm up with me if you will. La 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 la. I've still got it. I've got it. Okay, here we go. Happy birthday to you. Happy birthday to you. Happy birthday to Alex, Sinbad, Elijah, Kristen, and Quaylick. Happy birthday to you. Red Pen comes comes in with a quick. We need a verse 2 for Miss Chris MC. We'll add Miss Chris MC for sure. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, dear Miss Chris MC and Nana's grandson Jameson's. Happy birthday to you. Nanny's grandson Jameson. Happy birthday. 7. The big 7. Pretty soon it'll be the big 1-7. Before you know it, I'm telling you, enjoy these young years. Told you it was manually added. All right. To everyone who's celebrating their birthday today, happy birthday. I realize there are many wonderful days, but today is your special day. There are a million people you could have celebrated with, and at least a million people a million places you could have been, but you chose to be here with us. The privilege, pleasure, the honor, the joy is ours. Help yourself to free pancakes. Wait, hopefully we plan to return that joy back to you, make your day a little more specialer. Help yourself by free pancakes. At Denny's, IHOP Village and Waffle House, McDonald's, Tammy Dunlap's House, Andy's Grill, Bob Evans, and Cracker Barrel. Okay, so I messed up the my part of that. That's on me, but I think you get the gist of it. Free pancakes on your birthday. If the company doesn't support free pancakes on the birthday, do they even want customers? I mean, really. Miss Chris MC says, Kristen is me. I got double. Y'all are awesome and made a 43-year-old special. You double dipped. Happy birthday. Happy birthday. 43. That's young. I remember when I was 40. Vaguely, I remember when I was 43. All right, we've got a drum solo to finish up the birthday song. Help me with that one. Seriously. Get your drumsticks out. Let's do this. Beautiful. I did the double crash on the end there, if you noticed. So Josh is like, so I did it correctly, right? Yes, I believe so. We just did a little double dipping, which is great. It works with all sorts of things like fondue. You can double dip, right? Isn't it okay if you're having, correct me if I'm wrong, if you're like dipping something in chocolate, you can like take a bite and then re-dip it, right? It's not like you're dipping a cookie in someone else's milk twice. That would be different. You don't do that. You can do like a single dip as long as your fingers don't touch. That's acceptable. Like Oreo with my wife's milk. One time, one dip. Fingers don't touch the milk. But fondue is double dipping. It's approved, right? It is No Pants Friday. I'm participating in this. Taxi Horses, thanks for the reminder. Let's see. No on the double dip. But fondue is different, right? Do not get your DNA. It's because everything sticks, like it's covered up, right? Now I'm not an alcohol drinker, but you can pass around a bottle of alcohol without a problem. Clearly fondue should be. Should I update the photo for No Pants Friday? Now, Greeners, we'll pass on that one for now. I think we're good on the photos. I appreciate your work and your exuberance to incorporate just every aspect of the show into a photograph. But no, that kills all the germs, though. Doesn't chocolate? It should have some sort of property like that. All right. You put a Phantom 6-volt bus in there as well. Awesome. We need to get him in there. All right, let's go to court. We have a day of court hopping, and I don't apologize for this because we are so excited for the big case that we're picking up on Monday, and it's Kouri Richins. And so help me, if she takes a plea deal Monday morning at 8 o'clock, I'm personally going to fly out there and give that judge a piece of my mind. At some point. Not like that day, but we've put in a ton of effort to get to where we are with that case, and we're really looking forward to it. I think you guys are going to enjoy it. Great personalities, strong lawyers, fun arguments as far as the back and forth. It gets spicy. Great judge, good audio, good video. Thanks, shout out Court TV for bringing the good cameras. Super excited about all that. So join us starting on Monday for live gavel-to-gavel coverage of that. Let's see. Josh just says mod chat, so I just have to scroll until I see something that looks interesting. Greeners is adding it to a calendar. Oh, this is a trial we may be interested in later this year. was Warren County, 3 o'clock today. There's pre-trial. Okay, I hear you. I just had to find it. Ow! Do you guys see that? You didn't because my head was in the way. But I just hit this nice metal thing with my finger. I would show you the owie, but it was the middle finger. So I would have to be like, it's this one right here. I just whacked it like that, and it didn't feel good. Yeah, clip it. That hurt. Clip it, says Greeners. Clip it. Clip it for the bin. I tell you, I got so much rest last night, but I just don't feel like I slept at all. I don't know how that works either. Does she have a plea deadline date? I don't know if they do. A lot of courts will let you change your plea right up till the moment. It's one of those, hey, it saves the court money, it saves time. Why impose a deadline if they want to, agree to what the prosecution wants and, cut all this expense and time and hassle. So Judge Boyd has a deadline date. She holds fast to that, though. Trying to eat some crisps around my clingy child. How many do we think will end up in his hair? About 50%. I'd say about half of each chip is what I'm thinking. Half of each chip is my bet. All right, let's go here. Let's just jump to court, just right off the bat.
Probation or parole right now?
I'm on probation.
Uh-oh.
Out of what court are you on probation?
Mm.
Do you know which court or city? Redford. Okay. Do you have any financial ability to post any bond on this 25 case?
The money is not looking good, but I was gonna try to see if I can put my car title up, if that's possible or something.
Oh, okay.
That's a no. That's a no, says the judge. That's not money.
The failure to appear twice. What was going on in June of 25 that you failed to appear? Were you in custody? Were you?
June 2025.
June last year, June in 2025 that you didn't appear.
So like I said, I've been so busy during that time, and like I said, I was just collecting tickets and forgetting about them. So
okay, well, why is that a bad habit? Tell me what you learned from that.
I was collecting tickets.
Yeah, I'm learning now.
Yeah, now we're in a big mess, right? We're in a big mess.
Yes.
I don't want to work a financial hardship. You already don't have a license. It's got to be very difficult to make a living with no license. You can't keep driving like this, okay? So you got to go to Operation Drive, and you better start saving up your money to pay your fines and costs, because that's the way out. So you got to make good choices, and you really shouldn't qualify for a personal bond. But in the spirit of Operation Drive, the court, are you going to, let me ask you something. You have other matters today that you have to clear? Mr. Andrews?
Yes, Your Honor.
If I post a low cash bond, does that benefit him in getting credit for time served? Or is he going to get things cleared today and a financial bond would prevent his release? Which is the path here?
He's got two other matters outstanding, one in Oak Park and the other in Hazel Park. It's going to be similar. It's similar to these matters. So, I guess depending on what the court does today, I'll be able to advocate for him if he's going to be in this program, that the court kind of follow what Your Honor would do.
Okay, so you want a low cash bond or a personal bond?
Sir, can you come up with anything today?
Like I said, my older brother is locked up, and I know my dad was trying his hardest to get him out, and I just, somehow got in.
Okay, so please make better choices. Your dad's running around like he must be so worried about you guys. Think about your family when you do these things.
I guess I would ask for a personal bond. And,
okay, the court's going to order a $2,500 personal bond. No money's due at this time. You know what's a violation of this bond? If you drive without a license. So let's get it together. Got a lot of tickets. You got a lot to get organized, but we're going to put you in Operation Drive. We'll set this matter for a pretrial in Operation Drive. You will have assigned counsel. The notice to appear will be sent to Auburn Street. Okay? So the conditions of your bond are, I forgot to read this, you have to personally appear for any exam, arraignment, trial, or sentencing, whether that be by Zoom or in person, as ordered by the court. You have to abide by any judgment, enter in this case, surrender to serve any sentence imposed. Do not commit any crime while released. Do not drive without a valid license. You shall immediately notify the court in writing of any change of address from Auburn Street in Detroit, or the phone number ending in 1500. Okay, we'll set this matter for a pretrial. On the second case now, calling 2500194. This is the City of Royal Oak versus Mr. Nico Daniel. This is, since the defendant is in custody, the arraignment on this case was currently scheduled for March 12th, 2026 at 8:30 a.m. But since we have the gentleman before us, we're going to conduct the arraignment on the 26th case with the agreement and consent of counsel and the defendant. Your appearances, please.
Thank you, Your Honor. May it please the court, Donald Anders, P48501, on behalf of Mr. Nico Daniel. Sir, can you state your name for the record again?
Yes, Nico Daniel.
Thank you. Your Honor, I did get a chance to speak with him. He is aware of the maximum possible penalties of this charge. So for purposes of arraignment, we'd waive formal reading and he would stand mute.
Yep.
Okay, the court will waive the formal reading. Defendant stands mute.
Enter not guilty on his behalf.
And in the interest of time, can we duplicate everything that was said in the first case and apply it to this case?
Yes, Your Honor.
And may I proceed then to the bond and bond conditions?
Thank you, Your Honor.
I'm going to take what you said in that case and apply it here. So
yes,
I
we're
was
asking for
an identical bond.
Thank you, Your Honor.
Okay. Any objection to that, sir?
No.
Okay. Do you understand that everything I said in the first case applies to you in the second case? There's two bonds of $2,500 each personal. Okay.
Yeah.
Okay. So this is going to be an Operation Drive 2. You got to appear. You got to help us help you. Got it?
That's
right?
What I need.
Yeah,
That's
well,
what I
we're
need.
here to help. So you got to help us. You got to cooperate. Okay, sir?
Yes.
Okay, that concludes the arraignment on both cases unless something is unclear or has not been handled in the 26th case.
Your Honor, did you give him dates yet or?
No, I don't. I don't
Okay.
possess that power. I don't do the scheduling. But
Very good.
it's going to be sent to Auburn Street. So if you're in custody and things don't get worked out, you got to check with the court and appear for your hearing. They're probably around 30 days out. Okay?
Okay.
Daniel, you understand? Make sure you show up to your court date, Mr. Daniel, no matter what.
Please. Is that a song? I'm begging you, please. A lyric is coming. Pretend I'm singing you that song. You have to appear.
Okay.
All right. Thank you. You gotta,
you,
you know,
What
your
song was
dad's
it?
running
Eric, I
around
thought
taking
that was
care of
funny.
you guys. Like, you know, get it together. You can't just say I got too many tickets and put it away. Like, deal with it. A closed file is the best file. And the best break for you is being in Operation Drive. So take advantage of what this court offers you. Not all courts have these programs. Okay?
This is true.
Yes.
All right.
The court's
Good luck
trying to
to you,
help you
sir.
get back
I
to
appreciate
a
you.
legal driving status.
Yes. So I just got 2 questions.
Oh,
Yes,
sure.
sir.
So I will be able to get out today.
Well, on my case, not my cases, this honorable court's cases, your 44th district court cases, you don't have to post a bond. Your attorney, Mr. Andrews, says that you have other cases and they're going to have different bond and bond conditions. But on these 2 cases today in this court, you don't have to post any money.
I
Okay?
appreciate you.
And you do not have to appear on March 13th for the arraignment on the 26th case. Okay, the newer case. We handle that today. The next thing you have to appear for is a pre-trial. Got it?
All right.
Okay, and it's going to have a Zoom ID. And if you can't If you don't know how to Zoom or you don't have the capabilities, come to court and we'll set you up.
Okay.
Okay?
Free Zoom window
The
at court.
Operation Drive, that would be mailed to the house? Is that how I would be
That's,
able to?
it's not going to say Operation Drive, although there might be an information sheet with the mailing, or you might
It's
get
just
that
like-
at the pretrial. But the notice to appear for the pretrial, it'll say notice to appear at the top, and then I'll have pretrial on it. That's going to get mailed to Southfield, right? No, Detroit. I'm on Auburn. It's going to go to Auburn.
All right.
All right, get this stuff organized. You can have a better life.
Thank you.
Okay, thank you so much. You may leave the Zoom. Mr. Andrews, thank you for assisting this litigant and the court this morning. The court appreciates your assistance.
Thank you, Your Honor.
Take care and be well.
Yeah, he'll send a bill.
I'm all set.
Yes, you are. Thank you so much. Good luck to you, sir.
He doesn't know how he got picked up. He's just out there collecting tickets and ignoring them. Hello, Erickson.
Okay.
How you doing?
How many arraignments do I have that are ready?
Well, you got Benjamin Moore.
We have one ready in the 9:30,
Okay.
Mr. Moore.
I'm going, Deputy Koki, I'm going to take this criminal matter at 9:31, and then I'm going to your cases, and both defendants are here on your
Criminal.
docket. Whoa, 1 second.
Theft?
I have Mr.
What do you
Moore,
think?
right? 1 second, sir.
I think it's going to be theft. Retail fraud.
Calling the case number of 2600095. This is the City of Royal Oak versus Mr. Benjamin Moore. Your appearances, please.
Good morning. For the record, Patrick Agnick on behalf of Mr. Moore. Mr. Moore, if you want to state your name for the record.
Benjamin Moore.
Thank you for that. No objection handling the matter by Zoom this morning. I did speak in private to Mr. Moore just now prior to proceeding. He did acknowledge he does understand what he's charged with. I'd ask the court to waive any further reading, request a not guilty plea to be entered. This is not an Operation Drive case. He did confirm
Sounds like
the
traffic.
address in Detroit on Gallagher. That's a valid mailing address for him.
Okay. Did I get a phone number chatted?
You know what? I will chat that to you right now. My apologies.
Okay. And is assigned counsel requested for this gentleman?
Correct statement.
Okay, that's granted. Counsel
this.
shall be assigned for you, sir.
Hit me up in the DMs. Or
Okay, so to recap, we're holding the arraignment. You consent to Zoom. You waive the formal reading. Defendant pleads not guilty, and not guilty plea is entered on his behalf. I've confirmed his address, and I'm going to get a chat here with a phone number in a second. Okay, so let's look at this. Counsel, while you're doing that, your video went out, but can you talk about bond and bond conditions? I've reviewed the file. There's minimal, if no, very minimal criminal history, and this is a driving offense. So what say you,
My
please?
screen was down for the
Yeah,
chat.
that's okay.
I believe this may be a misunderstanding that he may very well have been insured at
Okay.
the time the ticket was issued. I've explained that to him, but he's going to provide that documentation to me prior to the next court hearing. So I do believe that it is correctable. He should be insured at the moment. Obviously, it's a traffic matter. He appeared here timely. I believe that a personal bond would be warranted.
The court is in agreement. The bond is $2,500 personal. No money's due at this time with the standard court rule provisions, except that he's free to travel. You may these are your bond court conditions. Your bond conditions, sir. You have to personally appear, whether it's by Zoom or in person, like you're doing today, for any and all court appearances. The next appearance is going to be called a pretrial conference. Anything with your name on it, in this case number, you're required to be there. You have to abide by any judgment entered this case, surrender to serve any sentence imposed, to not commit any crime while released, and you shall immediately notify the court in writing of any change of address from Gallagher Street or the phone number ending in, and where is it? I got it. Your phone
309.
number. Is that the right number?
Yes.
Okay, thank you. Sometimes the chats blur together. I want to make sure thank you for providing that. Okay, so You have to notify the court in writing of any change of address from Gallagher or the phone number ending in 0935. We're going to set this matter for a pretrial. You will have assigned counsel. The notice to appear will be sent to the Gallagher address. Is there anything further requested or required of the court on behalf of Mr. Moore?
On this file, no. Thank you.
Okay, Mr. Moore, thank you for appearing today. You were early and you are dressed so appropriately and you conducted yourself in such a courteous and professional manner. The court really appreciates
Next time, use a ring
the
light.
courtesy and respect extended to the tribunal. Okay.
I got a question.
Oh, I'm sorry.
So I have to pay $2,500.
No, it's I have to put a dollar amount on a personal bond because that's just what the law says we have to do. But you don't have to post any money. It's a personal bond. I'm taking you on your word that you're going to appear before the court.
Okay.
It's a personal bond. You don't owe any money. That the next thing you have to do is speak to your attorney when he calls you and appear for the pretrial, and it'll be by Zoom. And if you don't have the ability to Zoom, you can always come to the court and we'll set you up on a device. Okay?
Okay.
So no money's due at this time.
Okay.
All right. Thank you. Take care. Be well.
Thank you,
sir.
Mr. Moore. I'll reach out this afternoon with my information, okay?
All right. Thank you.
Thank you. You're free to sign
Patrick?
off.
No, Patrick, we have your 10:01.
Patrick.
Okay, Miss Camel.
Yes.
I'm not a camel.
Good morning. Mr. Gagnick is going to be helping you. Whoops. And I'm going to put you in a breakout room with him. Okay.
I'm not a camel.
Okay.
You say I have to sign off. Mr. Gagnick, we have the 10 o'clock here for you. I thought you said I had to sign off, so I'm going to put you in a breakout room.
Not at all. Thank you.
We'll put him in room 2, and we'll put Miss Camel in room 2. Got it? Did they join? Good. Okay, I'm ready to call the informals with Deputy Kouri. We're first going to call Miss Erickson's case.
So she's been patiently waiting.
But if Mr. George could listen, what I say in Miss Erickson's case applies to you. So if you could please listen, that will help us go faster. Who's Dominique C?
Does the judge have like an American flag scarf?
They appear.
Or is it diamonds?
Oh, will you
Blue
rename
diamonds.
that and send Patrick a chat? Maybe. I didn't see that. That should have went first. Okay, calling the case of 260S01610. This is the state of Michigan versus Elizabeth Nicole Erickson. Your appearances, please. When I say that, that means tell me your legal name. We always start with the deputy and then the defendant driver. Your appearances?
Deputy Kouri.
Okay, your appearance, ma'am?
Yes,
Your
good
name?
morning, Your Honor. Elizabeth Nicole Erickson.
Oh, she's a
Hi, how are
she's
you?
a ventriloquist.
Good, how are you doing?
Good. Okay, so both of you have appeared, ma'am. You have, as appearing today, you have to make a choice out of 3 options. You can admit responsibility to the ticket as written, and then it goes to me to assess fines and costs. No one ever picks that, but it's definitely an option. The next one is you can admit responsibility with explanation. That's where you admit that you did what the ticket says you did, which is disobeying a traffic signal, but you provide an explanation. And that's the explanation as to what was going on that day that caused you to meet the officer on the side of the road. In your explanation, it's important that you admit responsibility. We don't argue. We don't deny. We're not combative. We're admitting we did what the ticket says we did. We explain to the office, to the trooper, why, deputy, why. You should address how you addressed him on the side of the road. If you were anything less than polite, courteous, respectful,
Now's a chance to
deferral,
apologize.
all those good positive words. It may be difficult to get a break today, and or anything that you've learned as a result of this. Upon hearing the explanation, the deputy may, operative word may, he is not required or obligated to make a motion to amend the ticket to something less. By less means less points and or less fines and costs. Know that he's not obligated to do so. He's the only person on the Zoom that has the power or discretion to make any such motion.
Option
I
4 is to
cannot
fight
order
it
him
out in
to
the
do
octagon.
so. At that. So please know that if you admit responsibility or admit responsibility with explanation, if there's no motion made, you will exit the hearing with the ticket as written. If you admit responsibility with explanation or flat out, there's no right of an appeal. You may file a motion and ask that your party admission be set aside. You will have to post a bond. There's no guarantee that the motion will be granted. The third option is you deny responsibility. That's where you say to the court and to the deputy, the ticket's wrong. I didn't do what the ticket says I did. At that point, I swear in the witnesses, I take in testimony or any other evidence offered by the parties. Let the record reflect that this defendant driver has sent in an email with PDFs to the court, which are in the court file.
Oh, she's going to fight it. She's going to fight
in
it.
the informal hearing, the deputy has the burden of proof on the behalf of the people of the city of Detroit. If I find by a preponderance of the evidence, it's just by a little bit more that the deputy proved that you did what the ticket says you did, I must find you responsible. Going with an informal hearing is an all or nothing proposition. You will exit the hearing with the ticket exactly as written, with all the fines and costs and points that come with it, or you will exit the hearing with no ticket at all. At the end of the informal hearing, if either side, the state of Michigan and or the defendant driver, are unhappy with my ruling, you may file an appeal and have a new hearing with the trial judge. By proceeding today with an informal hearing, all of the drivers give up their right to be represented by an attorney. You give up your right to be represented by counsel and or a jury. Having said all that, Ms. Erickson, what is your choice?
I would like to admit responsibility with an explanation, please.
And what would you like the deputy to hear about you, ma'am?
Yes, I would like to begin by acknowledging the hazardous weather conditions on January 19th. That day involved significant snowfall and widespread traffic accidents throughout the area. As you will see through my submission, there was an 100-car pileup that day. As I did approach the intersection, I did see the light turn yellow and I attempted to stop, but my vehicle was not as effective as slowing as I stopped at that moment. I had to make a split decision about the safest course of action, and it was by not continuing to slide into the middle of the 8 lanes of Woodward. This was not an act of disregard for the traffic signal. It was not a distracted speeding or driving recklessly. 2 days prior, I had gone to get my car examined, and I had been advised to replace my brakes. I have since completed that repair and have taken the corrective action to ensure my vehicle is fully safe. Given the weather conditions, my prompt corrective measures, and otherwise responsible record, I request that the court please consider a non-point violation or otherwise mitigate the penalties.
Wow.
I know you said that and you sent this big raise thing, but I don't see the word brakes on here at all.
Oh, it's in the bottom,
On this-
very bottom. Yeah, should be the very bottom part.
Oh, recommend brakes. Okay. All right. Deputy
you were
Kouri,
driving a
having
car
heard
with
all that,
bad
is there
brakes and
anything
you
you would
knew
like the
it.
court to consider on
In bad
behalf
weather.
of this driver?
Your Honor, I wish to amend it to a limited access 1 to 5 for 0 points.
Okay, so right now,
Winner,
to
winner,
explain
chicken
the
dinner.
motion, you have disobeying a traffic signal, which is $130 and 2 points. And he's making a motion to give you a speeding ticket. Limited access means on the freeway, it's 0 points and $130. Do you have any objection to the motion?
No, that's fine.
Okay, no objection. The motion is granted. Ma'am, do you admit responsibility to limited access 1 to 5? Do you admit responsibility to limited access
Yes,
1
sorry,
to 5,
correct,
Ms.
yes.
Erickson? Okay, that will be $130. How long do you need to pay?
Just let me know how to do it. I'll do it today.
Okay, I'll give you 7 days to pay. You can pay online. You can call the court and pay over the phone. You can mail us a check or money order, or you can come to the court. I always look at you because I can't remember them all. But give us a minute because the file is still in the court. So give us a minute to update the file.
Okay, thank you very much.
Okay,
I appreciate
thank
it
you.
on both your behalf. I'll mail the
Okay,
check.
thank you. May leave the Zoom. Calling the case of
She won.
25OS32633 and 2633A. This is the state of Michigan versus Mr. Desmond George. Mr. George, George is your last name, right? Did I get that right?
Yes.
Okay. Your appearance is police, and we start with the
Deputy
driver. Okay. I'm sorry. We start with the deputy. I'm sorry.
I know what you meant.
Okay.
Interesting
Okay. My
clothing
heart was in the right place. Okay.
for court.
And defendant driver, your name.
Desmond George.
How are you today?
Hanging in there.
Okay. Yeah. That's sometimes that's all we can ask. Okay. So, sir, were you present on the previous hearing where I laid everything out?
Yes.
Okay. You
What do you
have
wanna
2
do?
tickets, so you have to make the choice. One choice does not apply to both. You can pick different options on each ticket. So let's do your no proof of insurance. What's going on with that?
I have insurance on the car that I was pulled over in.
Okay, can you show any proof of that on this hearing?
Yes.
Okay. Can you hold up your phone or the paper to the screen, or how are we going to do that?
Okay, we have to zoom out because there might be some personal information. Kouri Auto Insurance. Looks like he's got a 2021 Toyota Camry LE.
Your Honor,
What?
a motion to dismiss the no proof.
Okay, so let's, defendant, did you want to admit responsibility with explanation on that? I had to get your choice. Yes.
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 Okay.
Yes. She
And
says
then
yes is the
defendant
answer.
had or showed insurance.
And then
Deputy
deputy motioned to dismiss.
There was a motion to dismiss. Okay.
Why does she have to go through
So
the
the
process
deputy
if
is
it's
making
a
a motion to
motion to
dismiss
dismiss?
this ticket. Any objection? We'll make it go away. Okay.
Thank you.
So that's granted, and there's no money due on that, and the A ticket is gone. Okay, do you understand that?
Yes.
Okay, now we're moving to the disobeying a traffic signal ticket. What would you like to do on that?
What was the same thing I did for the last ticket? The expansion.
Okay, you want to admit responsibility, and you want to give an explanation to Deputy Koki as to what was going on.
Yes.
What happened, and tell him like what you've learned, and go ahead, talk to him.
That day, man, I was at a turning signal. When the turning signal turned green, it was like 2-3 cars in front of me that didn't proceed to turn. And as I proceeded to turn, the light was turning red at the same time I was turning. So it gave definitely a reason to probably pull me over. So I definitely understand. I could have waited, but I thought I had enough time that last split second. But I guess I did.
Okay, have you made any changes in your driving habits as a result
I don't
of
let
this
2 or 3 people ahead of
experience?
me.
Yes, I definitely take my time, be more patient, and just be more patient now, and just wait and just wait.
Wait your turn. Okay.
He's got an
Deputy, having
inappropriate
heard
shirt
that
on.
explanation, is
Just
there anything you would like the
guessing.
court to consider on behalf of this gentleman?
Your Honor, he said exactly what happened. He admitted it 100%, fully and honestly. I wish he admitted to an impeding traffic.
Okay.
So you win another $120 ticket.
Isn't it refreshing, Deputy, when people just take responsibility? It's just such a rare thing in this day and age. And so it warms my heart just like it
warms my heart, and it
warms your heart. Okay,
fattens our
Mr.
coffers.
George, this is what is occurring. Right now, you have disobeying a traffic signal, and that is $130 and 2 points on your insurance. The deputy, because of the way you conducted yourself and the explanation you gave, and you took responsibility, he's amending the ticket to a double parking ticket called impeding. And it's a non-moving violation. It doesn't go on your record with the Secretary of Points, and it's on the Secretary of State for points. It's 0 points. Do you have any objection to a double parking ticket?
No.
Okay. So do you admit responsibility to impeding?
Yes.
Okay. And how long? The fine is $175. How long do you need to pay?
The fine went up. Points went down.
What to pay?
How long do you need to pay? You need a month? I couldn't hear you. It cut off.
30 days.
Okay, the court's going to give you 45 days to pay. Okay, there's 3 ways you can pay. You can pay online, on your phone. You can call us and give us a credit card over the phone. You can come to the counter. We're always happy to help you and have you here, and pay in person, or you can mail us a check or money order. Okay, but I'm giving you 45 days to pay.
Yeah, no problem.
Okay, the other ticket's dismissed. So you're exiting the hearing with no points and no fines and only no points and only $175 in fines. That was very nice of the deputy.
Thank you so much.
Okay, thank you. You, sir, Mr. George, be well on the road. Deputy Koki, thank you. You were so nice today. I appreciate you.
Yes, sure.
Take care and be well.
All right,
Yes,
we have
I take my arrangements.
Is this the one, Josh? We have a case in.
I'll be right back, everyone.
Okay. Well, you're going to leave, and we're going to go over here. Warren County Courtroom 3 has a hearing that's about to begin for a trial that we may try to follow. Thank you, Josh, for finding this one. Let's give him a minute to get everything in order. Let's see.
You're going to do the signature on file.
It's a murder trial.
SOS, all in caps, okay? So patient's signature, you're going to put the signature on file.
Sorry, that was the wrong audio. Points don't earn the city any money, right? It all goes to the insurance company. Why let them have all the fun, where instead you can have the officer look like the good guy, raise the fee, and pad the wallet. So Wisconsin's got it figured out. This is about his wife. Yes, this is let me tell you a little bit about this, because Josh sent me a little background on this particular case. This is a pre-trial hearing today. He's charged with murder after a woman dies at the Deerfield Township firehouse. 77-year-old man is under arrest on a murder charge after a woman died at the Deerfield Township fire station, according to, this is WXIX Cincinnati. This was, let's see, back in the day. Where's the date? I don't have the date right here. Deputies detained a person of interest at the scene, identified him as Gerald Olin Finley of Loveland, booked him into Warren County. Looking at the posting from the sheriff's office on Facebook. And I'm going to sneeze. WXX is our local Fox station. This is Legally Blonde. Let's see. Responded to the Deerfield Township Fire Station regarding a person with a gunshot wound. They attempted life-saving efforts, but the victim was determined to be deceased at the scene. That's an echo. The deputies detained a person of interest who was on the scene. It's a homicide investigation. And, so 77-year-old man charged with shooting his wife at the fire station. Of all places to do it, I don't know why there was chosen, but we'll probably hear more as we proceed into the hearing. What does he have in front of him that he's writing on? I don't know. They might be looking at documents. They might be looking at possibly even a plea deal could be going on right here. That's weird. No, this is basic rights things. The sheriff, you've got a badge on the guy's shirt. Looks like he has his friend there to support him. Give him a minute. Looks like a familiar prosecutor, too. Sneeze number 7 on the books. Happy Friday. Dana Grand Jury, good to have you here. Welcome. What year did this happen? I don't know. The article, well, let me actually just check. The posting shows September 7th, 2025, so this is last year. He claims it's a mercy killing because his wife told him she was sick and didn't want to live anymore or something. Oh, man. Okay. These are harder. These are harder. But the law is what the law is. So, do I have a cold too? I've got a doozy of a cold, and I'm trying to kick its butt. Remember when I interviewed Judge Oda, he told me about this case as Legally Blonde. Oh, yes. Legally Blonde. Depending on when this happens, maybe you'll be able to go visit. It's number 8. Why at the fire station? Probably because, they have the fire station typically houses the ambulance as well. And they'd be able to take care of everything going forward. I guess it's convenient, but the charges would seem to indicate that that this type of killing is not one that's permitted in the state of Iowa. Mercy killings. Judge Oda is back.
This is the case of the state of Ohio versus Gerald Finley.
Maybe put it right there.
This is the case of the state of Ohio versus Gerald Finley. Can you hear me okay, Mr. Finley?
Yes.
Case number 25 CR 43025. Present before the court is Mr. Finley, right? You're Mr. Finley, right?
Yes.
Represented by Mr. Wendell. We have Mr. View and Ms. Trainer from the prosecutor's office, Officer Henry from probation. We are here today for a pretrial, but it's my understanding Mr. Finley is going to enter a plea of guilty to one count of murder with the firearm specification, and that we're going to go forward with sentence today. Is that right?
That is correct, Your Honor.
All right. I also understand that there is a stipulation as part of the plea that Mr. Finley has been informed that he has the right to have a hearing on the issue of the notice of requirement to enroll as a violent offender, but he is going to waive that, agree that he's the principal offender, and that applies to him. Is that right?
That is also correct.
All right. Mr. Finley, how old are you?
I think 78.
How far did you go in school?
I had 2 years of junior college.
Are you able to read and write English?
Yes.
Are you under the influence of drugs or alcohol?
No.
Are you taking any medications?
Yes.
What medications are you taking?
Oh, I don't know.
Well, let me ask it this way, Mr. Finley. Are you taking anything that would interfere with your ability to understand what we're doing here today?
I don't think so.
Are you a United States citizen?
Yes.
We've had some discussions about your case. If you enter a plea of guilty to this charge, the notion is to go forward with sentencing today, that you would be sentenced to a period of incarceration of 15 years to life, plus 3 years for the specification. So it would essentially be an 18 to life sentence. Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this charge against your will?
No.
78?
I have a document here entitled Change of Plea and Entry, and it looks like on the second page is a signature above the line defendant. Is that your signature? Tell you what, Ms. Brooke, why don't you go show that to him?
What is it?
This is the plea form that we reviewed together, and he's asking if that is your signature.
Yes.
Did you review the document with Mr. Wendell before you signed it?
I did, didn't I?
That was yesterday.
I'm having a real hard time with my memory.
Okay.
Yeah, but yes, yes.
All right, you and Mr. Wendell reviewed this form together.
Yes.
Are you satisfied with the representation that you have received from your lawyer in this case?
Yes.
You're going to enter a plea of guilty to one count of murder. This is an unclassified felony. It's punishable by up to 15 years to life. You're also going to plead guilty to a firearm specification. That is a 3-year firearm specification, which will be served consecutively to the 15 years. We also have the issue of your duty to register and to enroll as a violent offender. There's a complicated statutory procedure for that, but the simple part is you have the right to file a motion to contest that, but as part of this plea agreement, you're not going to contest that. You do acknowledge that you're the principal offender and that you're going to register as a violent offender in the event that you ever get out of prison. Do you understand that part of it?
Yes.
All right. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial. You can compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge and the specification, you're going to waive all of those rights. You're going to admit that you did it, and we're going to get on to the matter of the sentence. Is that what you want to do?
Yes.
We also had what we called a motion to suppress in this case. I issued a decision indicating that some of the statements would be admissible against you that you made, and some of them would not be admissible. You also have the right to appeal that finding, but if you enter a plea of guilty to this charge, you are agreeing that you are not going to contest the rulings that I had on your confession. Do you understand that as well?
Yes.
All right. Mr. View, Ms. Tranter, what are the facts?
Your Honor, if the case were to proceed to trial...
Mr. View, I apologize for interrupting. We've had the opportunity to confer with the victim in the case?
Yes, Your Honor.
The victim representative?
Ms. Kennard's been in contact with the victim's representative, notified her of our intent to proceed with the plea today, what the plea was, and the outcome that we expect.
Okay, go ahead with the facts. I'm sorry for the interruption.
Your Honor, if the case were to proceed to trial, the state would produce evidence beyond a reasonable doubt that on September the 7th of 2025 in Deerfield Township, Warren County, state of Ohio, that the defendant did purposefully cause the death of Amelia Vinegar, and that the defendant had on his person and used a firearm in order to facilitate the offense.
Anything on those facts, Mr. Windham?
No, sir. Thank you.
Mr. Finley, did you hear the facts that Mr. View just read into the record?
Yes.
Do you admit that those facts are true?
Yes.
Do you understand the rights that you're giving up by entering a plea of guilty?
Yes.
Is this what you want to do, Mr. Finley?
Yes.
What's your plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you have made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. It's my understanding that the victim is amenable to going forward with sentence today, and that is the preference of all the parties, right?
Yes, Your Honor.
That is correct.
Any reason not to go forward with sentence today?
No, sir.
All right. Mr. View, Ms. Trainer, on behalf of the state.
Your Honor, we would ask that the court enter a sentence of 15 years to life as to the murder count 2, and with an additional consecutive term of 3 years, mandatory as to the specification to count 2. Additionally, the defendant be found to be the principal offender and be ordered to report according to the violent offender database. I know under the statute, in terms of questions of fines and costs, certainly we would stipulate that he is indigent and would be unable to do that. We have no objection to the court waiving those costs and fines.
Ms. Wendell?
Your Honor, thank you. Certainly the sentence is by statute. We appreciate the state's stipulation relative to indigency. This is what Mr. Finley would like to do, and that's why he's tendered this guilty plea and accepts his responsibility in the matter. Your Honor, thank you.
Mr. Finley, what do you want to tell me, if anything?
Nothing. No.
All right, the court is going to impose a sentence of 15 years to life. I am also going to impose an additional 3 years on the gun specification. This will be served consecutively to the 15 to life term. This is an indefinite sentence, but the 18 years that is on the front end of this is all mandatory time. I do find that you're indigent for the purposes of fines and costs. There will be no financial sanction. I also find that you are to register in the violent offender database. That means that you are the principal offender and that you meet the statutory requirements in that regard. Is there anything else we need to do or anything that I forgot?
Your Honor, only I sent the draft sentencing entry, and I neglected to put the it's 3 years on under the imposition of the sentence where it says as to the specification to count 2. I left the 3 out there. So if the court wants to just,
I can just fix it right here. I have it on my screen.
Other than that,
It just says a year mandatory. You want that to be a 3-year mandatory prison term to be served consecutively, right?
Correct.
All right.
And I'm assuming the sentencing entry dismisses the balance of the counts of the indictment.
Yes, it's actually the plea entry that dismisses counts 1, 3, 4, 5, and the specifications to those counts.
Thank you, sir.
All right. Mr. Finley, you do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer, to obtain a transcript, or to pay the costs, they will all be provided to you without charge. Good luck to you, Mr. Finley.
Thank you. Thank you, Judge.
Okay.
Thank you, Mr. Trainer.
That's a tough one.
You're welcome.
It's a pleasure working with you.
That's basically a life sentence for a 78-year-old man. Some things that do concern me. He has trouble with his memory. He doesn't know if he doesn't think he's on any medication that might influence how he makes his decisions. Possibility for a plea appeal down the road, maybe. He just it left some ambiguity as to the situation, I think, when he did that. I'm sorry for those of you who get snow. Yesterday, I think it was 70 degrees here in my neck of the woods, which is right. That's all things right in the world when it's 70 degrees here. Right now, it's 71. So, I'm also surprised they didn't provide any information, didn't speak about it, and say this is what happened. Tony Zamora, welcome. Tony, where'd you go? Here we go. Welcome back to Attorney Level. Thank you very much for your support. One of our OGs and a great supporter of the channel helps us out, giving us information about court dates and updates and reminders for me. Time, start, stops. Tony, thank you, my friend. Appreciate that. Yeah, he's not in a good way. So I just don't see how that's, I don't know. The law is what the law is, right? And murder can't be allowed. Let's jump back to Christian Simmons' court and see if we have something a little more lighthearted.
was only one time when people was there.
All right, Your Honor, Mr. Perkins has changed his mind. He wants to run his preliminary exam.
You can have a seat. We'll call you in just a moment.
Okay, we get to have a full preliminary for Mr. Perkins, whatever his charges are.
So, let's see. We're running that one. We're running Hawkins.
Correct.
And what about Wiseman?
Wiseman, Mr. Raleigh said he was pretty sure was going to be a plea, but then he ducked out, so I'm not sure.
I don't think you're supposed to duck out of court.
His headache. There's just so much going on. What was that? Citizen. I want to give me a sinus headache.
Citizen, you're free.
Okay, you can brought up. No, it was crazy. The violence is percolating.
Good morning, Kurt. Great to have you here this morning. Hope you're doing well. Getting all geared up for Kouri Richins on Monday. Do not expect her to take a plea deal. I would be a little disappointed if we did. If she did, there's been a lot of lead up here. So, that being said, it does seem to be more towards one of the open and shut type cases. Not a big whodunit. Like the daylight in this courtroom, it looks nice. To tell you, let me show you one, Kurt. Here's a comparison. Warren County. Here's a courtroom for you, Kurt. Let's see, 6. How'd you like that one? That's some mood lighting. That's a live shot out of Warren County. The court's not working right now, but their camera runs 24/7. Oops. Where are we? Let's go back here. Yeah, very dark court. Bad things happen in that room. Has Kouri been in court already for this? This is her first trial, so she hasn't gone to trial before. There have been countless hearings and appearances and, you know, all sorts of motion, limine, you name it, that have led up to this over the years, since the death and up to the trial. So it's been delayed many times, and now we're finally going forward. They tried to move it. They tried to get a change of venue twice, but it is staying in Summit County, which is the beautiful Park City, Camas area of Utah, up in the mountains. It's the ski resort area. If Vail, Colorado lived in Utah, it would be Park City. It's a beautiful, it's a ritzy, high end place. Camas was like a poorer area, but it's become very trendy and posh. So it has a lot of older houses and stuff in Camas. Camas being what they call the gateway to the Uintas. You have to go through Camas to get up to the Uintas. So if you're going up to Mirror Lake to recreate at 10,000 feet in a crystal clear glacier-fed reservoir, you'd go through Camas to get there. Absolutely beautiful, beautiful country. You can go up from Camas and drive all the way up through almost sort of up out by Evanston, Wyoming, driving up through the mountains, and just incredible, rugged mountains, picturesque every way you look. I've done some amazing hiking and camping up there, and there is nothing quite looking at the stars from the Uintas. Clear sky, flat on your back, no moon. You can just reach out and touch the stars. It's beautiful. Let's see. Kurt, I see you calling out the jury selection for Kouri Richins. It does seem like they were able to obtain a jury incredibly quickly, considering the percentage of jurors who acknowledged having information about the case and, having followed it or knowing about it, things like that. Usually those people are sort of weeded out at the beginning, but apparently they got seated. Or some of them got seated. And I don't know how the questioning went, if all of them just swore that they could set aside their preconceived notions and opinions and any information they had heard before, and the judge said, that's good enough, and let it happen. I have to say, I like Judge Kresnik. He is a great, thoughtful judge, and I have a hard time imagining that he's like, yeah, we'll just let it fly. Any jury will do. I know he doesn't want to do this a second time. So we'll see how that happens. Are you doing coverage for Richins, Kurt, or panel or summaries? Probably. Kurt has some great legal mind information that we all can benefit from. So are we allowed to cuss in chat, or just Kurt asking for a friend? Kurt found a word that went around the blockage, so now I have to add the SS word to the list. So thank you for exposing the weakness in the program, Kurt. We'll fix that so it can't go too much further. But you notice I did not put it on screen nor say it. See how I sort of fixed it that way? But now I have to type it into... Glad to help. Yes, you'll send me a bill, right? Your usual fee. Oh, man. Good stuff. That's not it. All right, fixed it. Yeah, it was a typo, SHOT Show, which I accidentally typed initially into the blocked word list. I said SHOT Show, but did I just say it? Oops. There's a clip if I said it. I think I said SHOT Show, right? You guys would tell me if I didn't. All right, waiting for the judge to kick off this pretrial hearing. All right. See if we can keep an eye on some of the other courts. Generally today, Judge Simpson is doing landlord-tenant stuff. I think Judge McNally is also doing landlord-tenant stuff. Simpson is not quite live yet. Sweet. My daughter has brought in cold medication. Well, it's actually a glass full of milk, a package of graham crackers, and 2 Sudafed. So that's, we're gonna go with the medicated RA again today. That was so successful last night. Yes, you said shot show. Right. Okay, that's what I meant to say. So, but last day of court hopping before Kouri Richins, and then we're going to be in deep for a while. Let's see. Tammy Rogers is up. We can go check out her courtroom really quickly. Tammy, how are you doing? She's also very quiet today. Is that her? That doesn't look like her. Do we have an imposter judge? Okay, so one pill makes me smaller and the other makes me tall, and the one that Mama gives me doesn't do anything at all, right? Is that something like that? Is there a song about that? All right, done deal. Soup lozenge review yet? No, Thomas's should arrive today. We've been teasing this for quite a while. Progresso came up with soup you can suck on. They're Progresso soup drops. It is literally a jar full of candies that taste like beef broth, chicken noodle, and tomato basil. So I'm excited to open up the soup drops and give those a try. That will be, we believe, next week on the podcast. So boxes are hard. No New England clam chowder. No, I'm expecting them to come out with a more expanded version with all their other soups. If these are a hit, if they're good. That was a Jefferson Airplane song. Shannon says, I haven't tuned in a while. I need a break. How long is the Richins trial supposed to last? 5 weeks. It starts on February 23rd. It's supposed to go through March 26th, I believe. That's what it's slated for. There was a song by D12 Purple Pills. There was that song. I don't think that's the same song, Kurt. I think that's a different one. Amos, feel better. All right. I'm feeling better already, although I randomly just break out into sweat. So luckily I've had no fever with this one. It's just been a cold, but I think I need the fan turned on here soon. So is it soup or candy? I have no idea. I imagine, Denisha, that it's going to be very similar to just sucking on a soup bouillon cube. But it will have the texture of a Werther's. So if you can mix a Werther's with beef broth bouillon, that's what I'm expecting. Let's see. Wogger, they should have given you a list. I know it's a short list, but I'm not sure. I'm not sure this would be what you want. It's White Rabbit. After the show, look up the lyric after the show on someone else's computer, right? Blackbeard says not to make you all jealous, but there's a very handsome, great peer Yellow Lab mix head on my lap right now. Random sweat. Welcome menopause. That's it. More. Apparently, I'm going through either perimenopause or menopause, one of the two. I might be missing some key symptoms and qualifications to fully last that way, but I guess this is what it's like, right? Soup drop sounded like a Willy Wonka meal in a gum. It probably, the idea spawned from somebody who was watching Willy Wonka. Trying to keep an eye on both these quarts and see which one's going to start first. So let's see. We're in this one right here. We're going to keep an eye on both at the same time. Let's see. Can we do top and bottom? No, that doesn't work very well. Which way looks best? Where should we move everybody? I think that's the best way. Then whichever one starts first, we're going to jump to on the main screen. If you want to make RA jealous, you need to have a long cable in your lap, not a pet. Hey, I just got 200 feet of Cat 8 shielded and terminated cable. I'm a happy camper. I haven't even stretched it out yet. I need to because it doesn't fit on my spool because I wound it loosely, so I'll have to do that again. Civil law knows how to get the justice system. The wheels of justice just need a little poke now and then to get prompted. Okay. Simmons will start first. Simmons is in the bottom right-hand corner. She does, we'll jump to that one first. I'd like Simmons to start because it sounds like the gentleman just elected to have a pretrial hearing, which we basically get a mini court, right? We get a mini trial, an initial look at what the case might be, especially if it's one we want to maybe follow at a later point. Amos says, bottom right is my town. If you feel like you need to live in a freezer, it might be perimenopause. Okay, so I've got these graham crackers. I need Court to start because I need to dip graham crackers in milk, and it's a messy experience. I'm not sure if I'm going to be able to do it, honestly. I'm pretty sure it's effective at curing the common cold, but Ivan's still cherishing his youthful years, so apparently, Ivan, it will come for you. Just time has a way of menopause. By the way, when it comes to dipping graham crackers in milk, to get the most milk possible, you can only do about 3.5 to 4 seconds of dip in the milk, submerged. But then you have about 1 second to get it into your mouth before you get to the dissolve stage, which once you hit dissolve stage, it's over. You can't pick them up again. You basically need to, wash the table, the counter, and maybe yourself, depending on how unsuccessful you were at eating them. But if you do it perfectly and do the 3.5 second dip and then quick to the mouth, you just have a little bit of milk on your chin. And other than that, it's delicious. So ask me how I know. Put them in a bowl with milk. Then they get soggy, like really soggy. And, cake is good soggy. Graham crackers are not because they dissolve to a level of, it becomes a fluid, quite literally. Science. Yes, science. Should have been a podcast segment. We always talk about food on the podcast. So we had some interesting outcomes this week of just looking back. We had a case where This judge in the bottom right-hand corner threw out all the charges, dismissed the whole thing, even with video evidence of the felon in possession of a firearm, threw out that charge as well because of a lying witness who perjured herself on the stand. That was amazing. We've had, I believe, a not guilty. Was that this week? We had a surprising not guilty. We had a mistrial in Judge Boyd's trial with something that stemmed from a jury member after just one day, just one witness into a murder trial that was 24 years old with an extradition from Mexico. Mistrial in that court. And we had a plea deal for murder just now in Warren County this morning. So we have seen just like the full gamut of options and outcomes in courts just this week, which has been good. And then we're going to settle down for a long haul or a long case starting on Monday. So please bring a friend and watch that one. I think you'll want to hear the opening statement. So if you can anyway be there for the beginning of that trial, I think it will really set the stage for what's going to come over the next 5 weeks. Going to listen to the verdict music later today. This is Tanisha. I forget who it was. Someone emailed me and said, my girlfriend listens to your show. She really likes, I think it was the verdict music, or I'm not sure if it was the verdict music or my intro song. I would like to, might have been last week, I would like to, for Valentine's Day, give her this song as her ringtone on her phone. Can you get me a copy of this song? And I did. He's like, you're the best. So if you're out there, either the girlfriend or the boyfriend, whoever it is, because both admitted to watching occasionally, I hope you love it. Selena Kay is going to be going early on Monday, trying to get a wristband to get into court to watch the Kouri Richins trial. Obviously, Selena's been there before, being in the Utah area. I'm not to Kouri Richins necessarily, Selena, but this is an area you're familiar with. And I wish you the best in getting in. We look forward to on breaks when you're out of court to hearing some updates from what you've observed in the courtroom. Yo, Recovery Addict, my Nancy Guthrie rabbit hole theory appears to be holding more water by the day and has no credible ransom as requested. That was quite the rabbit hole, but yes, some things are shaking out that look like that could be a possibility. Got a new keyboard. I actually got two, a Ducky One 3, and a Ducky One X Mini. Trying them out, and I'll send one back. New keyboard is making me happy. Is it mechanical? And when you say Ducky, does it like quack, or is it yellow, or maybe I have to Google this. Hold, please. Ducky One. Do you know what exactly caused the mistrial in Boyd's case? All we know is it's attributed to the jury. Mistrial in jury. We heard audio. The defense asked to approach sidebar. They asked for it to be off of Zoom and off of YouTube. And the judge acknowledged that they wanted to approach regarding an issue regarding the jury. And then the next thing that happened after a long break was the court entered a mistrial in the record. So that's all we have there. That might be all we do get. The Ducky One has 3 cherry brown switches, which is what my old keyboard had, so that's working pretty well. So mechanical. Graham crackers were invented in 1829 by Sylvester Graham to promote a vegetarian moral lifestyle and to suppress sexual urges. Well, it's not work. No, just kidding. Just kidding. That's interesting. Apparently, graham crackers are not a Valentine's Day food. Who would have known? We also had the Judge Webster traffic case. Trying to remember what the outcome of that was, but I remember watching Judge Webster this week. Does each key make a different duck quack? Possibly. Josh says the Boyd case is going to be retried on June 2nd. That's probably the next spot they had available. They need like a 3-day window to try that one, so we might be able to go back and watch it on round 2. See how that happens. What keyboard do you have? Maybe I can learn from you. I got this. Let's see. I've got a Red Dragon K566 RGB. So it's got it does fancy lights that zip up and down. The whole thing does colors and effects and rainbow things, and it's definitely mechanical. It's a clacker for sure. That's my favorite keyboard. Of course, I've also got a couple of these Apple wireless keyboards, and oh yeah, here's another one. I've got both the USB-C and the Lightning wireless keyboard, and then 2 Apple laptop keyboards. So just the 5 is all I'm running right now. Oh yes, the Regier. Mr. Regier lost his case. We watched that this week as well. Thank you for the reminder, Red Pen. Mr. Regier shows up to court. He's prosecuting a truck driver out of Washington who English was not his first language. I think his name was like Muhammad or something. I don't remember exactly. But he shows up to court and is protesting, is trying to fight this ticket. It's running a red light in Kansas. The officer was on the other side of the intersection and filmed the whole thing with his dash cam. And Mr. Regier, Mr. Data, Mr. Computer, can't get the foundation laid with the officer to admit the video evidence. And without the video evidence and the officer being like, I'm not sure, I think it's what happened. The light, I guess it could be a different color other than red, because I only saw my side. The case got thrown out. The judge, you could tell the judge was mad. The officer was to blame for sure, but Mr. Regier also to blame. He should have sat down and reviewed that video with the officer before the trial. Anyway, that was interesting to see. I like to see cases where the law is followed on to favor the defendant, right? The burden of proof is high. The burden is on the state, and if they don't meet every aspect of the burden, there should be an acquittal or a not guilty or dismissal, depending as the case may be. And so that was good. Even though in my heart of hearts, I think he ran that red light. I think he's as guilty as sin. But it was good to see. Defense lawyer was on top of objections too. Yeah, and he knew that he was winning on a technicality. That was the funny thing. He's like, Your Honor, yeah, I understand this is a silly objection to make, because, but it is an objection. It is the rule, and we operate in a rule of law, and on our law has a bunch of rules. We have to follow those, and it's a technicality for a reason. So I'm sticking to my guns. I'm not going to just stipulate and let this officer watch the video and then remember what happened. If he doesn't remember, he doesn't remember. A win is a win. And now he gets to charge more for all the other truck drivers that run red lights. It's like, look, I got this guy off, and there was video evidence of him doing it. So that's why I charge an extra $100 an hour. Not sure what's happening in court here. It looks like
Mr. Jones, have you been in touch with Mr. Williams today?
Yes.
Okay. Was he going to be appearing with you for arraignment purposes this morning?
Yes.
Okay. He's not yet signed on, so I'll put you back in the waiting room until I see that Mr. Williams has signed on, okay?
Okay. Thank you very much.
Thank you.
Looks like Judge Simmons is about to begin. Some people are standing at attention. That was not Judge Simmons. Let's go back to let's go back right here. Let's see what's happening here. I'm gonna move so you guys can see this court. I'll be up top. Nothing happens up here in this courtroom unless they're sharing a video. Is Kouri the one who got aggressive with one of her lawyers? Kouri has had a couple lawyers. The last one that we really liked was Sky. Sky had impeccable fashion. A very tall woman. Her presence in the courtroom was noticeable anytime she was there. And also just fiery, like dressed to the nines, and just she used all the tools available at her disposal. She ended up withdrawing from the case after there was a conflict. I think there was something with a family law case, a separate case that presented a conflict for her or her firm. Before she withdrew, she filed a pile of motions, everything from dismissal of the judge, change of venue, dismissal of the whole prosecution team, dismissal of the case. She threw everything at the wall, and then as the final motion she filed in the same stack, it's like, by the way, I withdraw. So she literally burned all the bridges on her way out, just throwing everything at the wall. The next one that took over, thank you, Red Pen, Catherine Nestor, who took her place, is Tyler Robinson's attorney. So she is handling the Tyler Robinson, that's the Charlie Kirk shooting case, as well as Kouri Richins, which they're sort of, they're tracking at different times. The trials are different times, but Tyler Robinson case is ongoing, and there's actually going to be a hearing for Tyler Robinson during the Kouri Richins trial period. So she's working double duty on 2 high-profile cases. She's really good as well. So it'll be exciting. Now people are leaving. I think the judge has muted us. Why would she mute us? Because people are leaving court. Let's jump back to our two.
What time? Sorry, 9:30?
9:30 a.m. Yes, sir.
I have a circuit court sentencing at 9:45.
We could move it to Tuesday the 10th.
Okay. Oh.
So Mr. Jones.
Sorry. I have sentencing in Mason County. Is there anything earlier than that?
An earlier date, the 5th, March 5th.
Is March 3rd still an available date? I have several that day.
Yes.
Thank you.
Okay, I'm going to let them sort that out. It is possible that the walk to the dog letter was the reason that Sky had to leave. By that letter instructed people to do certain things that could have, if they occurred, made Sky both attorney and witness, which really starts blurring some lines and causes problems for the court moving forward. So it's possible that maybe we'll see Sky during this case as a witness for the state. Oh my goodness. Can you imagine? I don't know. Yeah, that would be, maybe it'll be in somebody else's trial. Needing a public defender looks bad for her in terms of her doing this murder for money. She had, you guys have seen, I've shown you previously, she was living a different life. She was very involved in real estate and flipping houses, and got in a mess where she was in over her head and was getting hard money loans. There's payday loans and then there's hard money loans. These are the behind the pawn shop, dark alley. The loan shark wears a ski mask when you talk to him. It's like the worst possible loan you could probably get. It would probably be more recommended to get a loan from your favorite drug dealer or cartel member above this hard money stuff. She was deep in financial issues, and her goal at some point was to buy this guy. this beautiful, beautiful, I don't know, 10,000 square foot home up in Camas, which was never completed. And she wanted it. Eric did not. Her husband was like, that's not a house you flip. That's not like you put in $10,000 in carpet and paint and turn it over for a $30,000 profit, and we walk away smiling 2 weeks later. This is a monstrosity. It's huge. It's massive. And the who wants this? Looks like Sims. It's huge. This is the Google Earth view of that home. So it will be mentioned during that trial. But it looks like a corporate retreat. I believe if we look at the progeny of the house, going back where it came from, where it started, whose brainchild it was, Lululemon, the owners of Lululemon, or at least high ups somewhere, are somehow connected to that home, and then they sort of either ran out of money or ran into problems of some sort and just never finished it, so it went up on the market. Ivan has never been on a corporate retreat. Ivan, you're missing out. You need to live with the bigwigs. Flying on the corporate jet is a rite of passage for many a professional. I've never done it myself either. I've had the corporate people fly in to talk to me, and I walked out of the room. That was fun. There's a fun story there. I'm not saying I'm the best negotiator when it comes to salary, but I knew I was good. And there was one time when I was a regional salesperson for a company, and my budget that I was supposed to hit was $1.5 million in sales for the year. And that's not a lot for a company the size that I had. It's not a lot. It was more than anyone else in my region. And I hit 3.25 million that year. And it doesn't take a lot of math to know that that's more than double what I was supposed to hit. And so when they came in and to do my review, and they flew in their corporate jet, and we went down to the hotel, and we were sitting in the hotel conference room, and they were discussing my success over the past year and how pleased they were to offer me a 2% raise. I looked at each one of them like this in the eye as they sat there. There were 4 of them, wearing their gold rings and, their expensive suits. I said, gentlemen, is that all you have to offer? And they're like, yes. I said, then we have nothing further to discuss. And I stood up and I walked out of the room. I went back to work, and my boss flew back, drove back, met with me immediately and said, look, I didn't realize you were maybe expecting a little more. I said, do you think? You did the math? You did the numbers? And he added an extra 10% on the raise right then and there. So I got a 12% raise. I said, okay, I'd be happy to continue working here. So that was fun. That was a fun story. And then I quit. But I quit for different reasons. I quit months later. I've had corporate people throw away my resume. What? Is it Lululemon or LuLaRoe? What? I thought it was Lululemon. Lululemon. Kouri's husband had a bunch of money. She wanted more. What's about love? Okay, she did want more. She was initially listed in Kouri's husband's will as the beneficiary of a sizable amount of money that would pass on to his descendants or to his chosen person when he passed away. Right before his death, he changed it to his sister because he thought, Kouri's out to get me. And she did not know that. So that's gonna be some spicy stuff there. All right, 2% is ridiculous. Yeah, 2% is less than the cost of living increase. It was terrible. The only thing that I felt bad about is that everybody else in the office basically got that 2% and were happy. But I was paying all the light bills that year, so. Let's see. Still waiting for something to happen in court, and it's not. We'll go around the horn one more time and see what's up. Let's do 6.
Let's get him out of here.
Dave? Your Honor, may I approach?
You may, thank you. So, our next case file here in the Wexford
four more to the sneeze count.
Refrigeration unit is People of the State of Michigan versus David Donald Charles Hill.
The judge just making a
file
comment
number
about
25-
the courtroom
14165FH. Appearances, please.
Good morning, Your Honor. Thomas E. Evans, appearing as Special Assistant Attorney General for the State of Michigan.
I'm Jeff Harrison. I'm here on behalf of Dave Hill. He's next to me at the table.
All right, thank you. You may be seated.
That right now, I will tell you.
All right, we are here today for a final pre-trial conference. What are we doing today, Mr. Evans?
Your Honor, I believe Mr. Hill is going to enter a plea under the following terms. As to the charges, the offer is to plead guilty to counts 1 and 2 as a habitual offender, second offense. In exchange for that plea, count 3 will be dismissed and the habitual offender third offense will be dismissed. Under the terms of Killebrew and Briggs, there is a further sentencing agreement. Number 1, dependent on Mr. Hill making his monthly payments up until the time of sentencing. And that is for a 11-month delay of sentence. If during that period of delay, Mr. Hill can reduce the arrears to $17,500 or less, the conviction will enter for 1 count of attempt failure to pay child support, and the habitual offender and original charges will be dismissed. If he's able to reduce the arrears during that period to 0, then 1 count of disorderly person will enter.
Mr. Harrison?
That comports with our understanding of the matter. As I discussed with Mr. Hill, the only thing that I perhaps failed to address with him would be his obligation to pay on his current child support obligation between now and sentencing. But we're willing to accommodate that to the extent possible as well.
Mr. Hill, is that how you wish to resolve today's case?
Yeah.
You swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, nothing but the truth?
Yes.
So you may lawyer. All right. Mr. Hill, you are currently charged on a felony information with 3 counts. Each count is a charge of failure to pay child support. Each count is a felony punishable by up to 4 years and or up to $2,000. Plus, there's a sentencing enhancement called the 4th habitual offender enhancement. That could, within the discretion of the court, increase the maximum punishment from up to 4 years to up to 15 years. That would also have an impact on the sentencing guidelines. I'm told today that you're going to plead guilty to count 1 and count 2, which again are failure to pay child support. Each again are a felony. Each are punishable by up to 4 years and or $2,000. And you'd also be plead, and then count 3 would be dismissed. And the habitual offender 4th would be dismissed, but you'd be pleading as a second habitual felony offender. Now, the impact of that is, it means that at the time of sentencing, within the discretion of the court, that maximum punishment for counts 1 and 2 could be increased from up to 4 years to up to 6 years. and from up to $2,000 up to $3,000 in fines and or costs. So far, is that what you understood you were doing?
Yes.
Now, if I accept that plea, the other portion of it, there's an agreement between you and the prosecutor as to sentencing. This is called a Killebrew agreement. Killebrew agreement is just an agreement where you and the prosecutor's office have made a deal. And that is, the deal says that I will do something for you at sentencing. And but if I don't go along with it, then you could withdraw your plea and come back to this stage of proceedings and continue negotiating, or just go to trial. Now, I have no idea whether or not I'm going to accept it because I don't know you. If I do know you and I have seen you, I apologize, I don't recall. But let's see what we got. The agreement is that you would continue to make your monthly payments. Means from now and until the end of a delay. Now, a delay is, what's going to happen is, right, if I take the plea today and I accept it, we'll set this for sentencing on a Monday morning, typically in about 4 to 5 weeks from coming from this Monday, upcoming Monday. Then at that time, if I agree, I'm going to place you on a delay of sentence for up to a year. Now, it looks like probation, sounds like probation, and talks like probation, but it's not really probation technically, even though I give you the same terms and conditions that I would for a probationer. They'll be not to violate any criminal law, not to drugs and alcohol testing, if I believe that. I don't know anything about you, but if you had any issues with substance use disorder, I could make that a term or condition. And there'll be other things like continue to pay on your child support. And this delay is for up to 1 year. That means that I generally push these out a little bit to help make sure that you're compliant. So after that period of delay, if you've been able to pay the arrears down, which at least at the time of the felony information was $34,840.05. If you reduce that down to $17,500, then you would withdraw your plea to counts 1 and 2, and then you would enter a plea to an added count 4 of attempting to fail to pay child support, which would make that a high court misdemeanor punishable by up to 2 years and or $1,000. Or option 2, if you pay that down from the $34,840 down to 0, don't forget the 5 cents, then you could withdraw your pleas again to count 1 and 2, and then enter a plea to an added count 4 of disorderly person. Now, this disorderly person charge is one of those, it's kind of like a hodgepodge, and it's got 1 in there for failing to care for a child. Anyways, it's a misdemeanor punishable by up to 93 days and or up to $500 in fines and costs. Hold on, did I get that right, Mr. Evans?
Yes, Your Honor. I just noticed a tiny little rumble with the 34, which is the amount contained on the information. Currently, arrears are down to 31,822. So yeah. I thought I'd just pass that on.
You understand? All I'm doing is looking at what.
Yeah, I know.
All right, good enough. Thank
That's
you.
what we were covering too.
I'm glad you guys are. I'm glad you're making those payments. Thank you. So far, Mr. Hill, has what I described to you, is that what you understood to be the terms?
Yes, yeah, he needs to pay up.
Now,
we're gonna cut away from that. You need to pay up, dude. Pay your child support. Judge Simmons is back. We're going to try to find her again. There we go. Let's go there now.
Going to be another misdemeanor offer in this case again.
Thank you, Your Honor. Additionally, the people are requesting a mutual sequestration order. The people are requesting, if the following people are here present in the courtroom today, that they remove themselves: Jalisa Ojeda, Meadow Sadal, Kyliana Parker, and Eric Rutledge.
How are these witnesses?
They are potential witnesses as trial, as they were present during the party. And additionally, there is a co-defendant that potentially they could be witnesses for down the road as well.
Some people did leave the courtroom, I'm assuming those are potential witnesses.
That's my understanding.
Okay. A sequestration is granted. Any additional matters?
Not for the people.
No, Your Honor.
You can have a seat. You call your witness.
Thank you, Your Honor. The people call Magdalene Young.
You raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Yes. You can have a seat. There's a microphone that's in front of you. The purpose of that microphone is so that the lady behind you can hear everything through the system, because a recording is being made and she has to be able to hear everything that you state, but that's not going to amplify your voice. So those of us in the courtroom need you to keep your voice up loud and clear, but specifically me, because your answers are so I can hear them, okay?
Okay.
If you need a answer or a question repeated, you can just ask to have that, or if you misunderstand something, you can ask to have it repeated. If there is an objection from either attorney, you stop speaking, because I have to make a ruling on that objection, and then I'll then advise you if you're allowed to give us the answer to their question, okay? If there's a yes or no question, I need you to respond yes or no's, mm-hms and uh-hs, or head nods and head shakes. They can't understand that on the record. So if you forget, we'll just ask you if it's a yes or no, okay? All right. State your first and last name and then spell both.
And spell?
Yes, spell your name.
Magdalene Young, Magdalen. Young.
Take your time. Okay. Again, if you ever need a break, you can just let me know, okay? You can proceed.
Thank you, Your Honor. Magdalene, I want to bring your attention back to April 13th of 2025. Were you at the location of 335 East St. Joseph Street?
Yes.
Is that in the city of Lansing?
Yes.
Ingham County?
Yes.
State of Michigan? And what's your relationship to that address?
I lived there in that apartment complex from October of 2024 to April.
Okay. Now, on that April 13th date, did you have occasion to be at apartment 14 in that building?
I don't understand.
So what was your apartment number?
My apartment number was 8.
And at some point, did you go to a different apartment in that building?
Yes.
And do you recall what the apartment number was?
No.
Do you recall where it was in relation to your apartment?
It was right above mine.
Okay. And what prompted you going to that apartment?
My bathroom was like leaking, like the ceiling was leaking, and I was friendly with my upstairs neighbor, and I knew that she was having a party, so I went up there just to make sure that maybe one of her like guests didn't like flood her bathroom or something, you know what I mean?
And did you in fact go to that apartment?
Yeah, I went upstairs and knocked on the door, and my neighbor did not answer.
At some point, were you able to speak with anybody at the apartment?
Two of the people who were like 2 of her guests, one of them was Taviana, and one of the other girls answered the door, and I asked them if the bathroom was flooded, and they kind of got all confused, and they told me no, and so I went back downstairs to my apartment.
And at some point, did you go back to that apartment?
They came to my door, my neighbor and all of them. They came down to my door. And I guess the people who answered the door before told my neighbor that I called the cops on them.
And what happened after that interaction?
My neighbor just wanted to ask, you know, and I told her I didn't. And I told her about the bathroom. And then we were talking for a while in the hallway. And they invited me upstairs. And they were a little persistent. So I went up there.
And what were you doing once you went back up there?
I was just like hanging around and talking to my neighbor, and at that time, Taviana.
Okay. And was Taviana someone that you had known prior to this interaction?
No. I did not know anybody there. Okay. The only person that I was like familiar with was my neighbor.
Okay. And do you recall what your neighbor's name was?
No clue.
All right. Male, female, something else?
Female.
And so you're in the apartment. What's happening?
Everybody was like sitting on the couch except for me, my neighbor, and Taviana.
Now, were you drinking any sort of alcoholic beverages during this?
I did drink a little bit of alcohol.
Do you recall about how much?
Throughout the whole night, I probably only had like 2 or 3 shots.
Okay.
I did not drink a lot, and I was really slow. I just wanted to like fit in, you know.
How were you feeling after those shots?
I wasn't feeling very drunk at all. And before I drank, Eric's and one of the other girls there were gonna like go to the store, and they were gonna drive there, and they were obviously not sober, so I offered to drive them to the store.
Okay. And at some point, did you come back to the apartment?
Yes, I came back with them.
And was there any point during the night in which something uncomfortable happened with this person you identified as Eric's?
We're about to bail.
Yeah.
Tell me about how that started.
I was already pretty uncomfortable when I was upstairs in the apartment.
I think we need to bail.
And I don't remember how it got to that point, but somehow I ended up on the stairs in the hallway alone with them.
And that's the end. I don't know why they cut the feed. Trying to find good courts, but we're not going to take an essay case on a Friday. Sorry. We can jump down to Travis County in Texas.
Yeah, we need to get this fixed. It's crazy.
Or apparently they need to fix something.
All right. Anybody else want to speak to that, Mr. Ziniker?
Yes, just briefly, Your Honor. The proposed order, while I don't disagree that paper citations, if we can get them, would be great. And I think everybody in this hearing agrees that the situation with Tyler Technologies is extremely frustrating. There is some relief requested that, at least as a third-party defendant in almost all of the cases in which my client has been sued, there's some concern about the language in paragraph 4, allowing filings and service to be effective upon email to counsel. I think there are some probably statutory concerns there and perhaps some due process concerns.
I agree, Your Honor. I will make sure I remove that from the Word version that I submit to Your Honor.
Why is the court reporter shaking her head vigorously?
Thank you, Your Honor. That's all I have.
All right. Well, I'll make sure that we look at the new version that you're sending and not at the one that was attached to the filing. All right. Thank y'all. Once again, I'm kind of at my wit's end about what I can do about this, but I will continue to rattle cages and see what I can do. All right, that brings us to the item 9, Easy Mixes, motion to clarify deposition protocol.
Yes, Your Honor. The steering committees did meet regarding all the motions set today, but with regard to this motion, we agreed on the majority of the proposed case management order that I submitted, with one exception. So the way that the order is written out, there would be one common issue deposition for any expert and corporate representative. And then there could be a case-specific deposition. However, the way that I laid it out is to have a case-specific deposition, you would need to seek leave of court, and that would only be for bellwether and or trial group designated cases. That seeking leave of court is where we disagree on. Some of the other parties, and I can't remember specifically what steering committees, but some of the other steering committees want an automatic case-specific deposition to occur. The reason that we would object to that is I don't think that there needs to be a case specific depot in every single case. I think almost all issues Your Honor has already certified common issues. And I'm sure you don't remember, but essentially what happened is every steering committee submitted their proposed common issues, and then we just pasted them all together and labeled it common issues. So it's very extensive. And I think in the cases where we may need a case specific, then we could seek leave of court. But allowing an outright prevents or goes against the whole purpose of this MDL, because then we would be right back at 157 case specific depositions and will never be done with the discovery process.
All right. I think we're going to jump to
No,
Kansas.
I agree, and I think it.
Attorney's fees.
We jumped to Kansas.
Have you ever been adjudged mentally ill by a court?
No.
Have you ever had a guardianship or a conservatorship set up to handle your affairs?
No.
Are you presently under the influence of any intoxicating liquors or drugs?
No.
Have you had plenty of time to discuss this case with your attorney, Mr. Watts?
Yes.
Do you need any more time to visit with him about the things we've just discussed?
No.
Keeping in mind the matters we have discussed, is it still your wish to plead no contest?
Yes.
Ms. Norris, could you provide a factual basis, please?
Your Honor, on October 4, 2019, near KF 254 and Southwest County Line Road, law enforcement did see the defendant's vehicle at around Highway K 254 and the Benton city limits, so well within Butler County. Defendant was pulled over, or defendant had pulled into a quick shop in Benton, and law enforcement did approach the vehicle. The defendant did, let's see.
She's struggling to spit this out. Use your words, ma'am. Use your words.
Yeah, Your Honor, law enforcement did try to approach him personally at the quick shop, and then he did go into, basically kind of fled through the store, and then went and got back into his vehicle and left the quick shop there in Benton, and law enforcement did pursue. There were multiple moving violations. Defendant was driving recklessly, going over 100 miles per hour, with other vehicles very nearby, and was passing on the shoulder. That'd be sufficient for the court regarding the felony flee and elude.
I believe so. Thank you, Ms. Norris. Mr. Watts, any comment regarding the factual basis?
None, Your Honor. 65.
All right. Mr. Hayes, the court finds that you are alert and intelligent, that you understand the nature of the charges and appreciate the consequences of pleading no contest. I further find that you understand the rights you are giving up by pleading no contest, and that the facts of the case would be sufficient for a finding of guilt. I further find your decision to plead no contest has been freely and voluntarily given after having received advice of counsel, I will therefore find you guilty of count 1, fleeing or attempting to elude an officer, a level 9 person felony. Ms. Norris, is there an announcement regarding the remaining counts?
Your Honor, state would dismiss the remaining counts of the information based on the plea.
All right, counts 2 through 4 are dismissed at this time. I am going to order a pre-sentence investigation be done, and we do need to set a sentencing date, at least 8 weeks out. Angela, are you familiar with when the correctional facility that he's in would be able to conduct a sentencing hearing?
I believe so, Judge. I have May 15th at 1:15.
May 15th at 1:15, if that works for calendars of council.
Yes, sir, I can do that.
All right. Do we jump?
Your Honor, that should be fine by the state.
Got a couple to choose from.
All right, Mr. Hayes, do you expect you'll be at the same correctional facility on May 15th?
Yes.
I'm not going anywhere,
Okay.
sir.
Any reason to believe that that date doesn't work for the correctional facility?
No.
Okay. All right, our court services department may be reaching out to you in some way. I don't know if that would be by mail or how, but they might have some paperwork for you to fill out in order to complete the pre-sentence investigation report. If you do receive that, make sure you comply so we'll have everything we need to have you sentenced when we come back in May. Do you have any questions, Mr. Hayes?
All right. No, sir.
All right, counsel, is there anything else we need to do with Mr. Hayes's case today?
So we have a
No,
couple,
Your Honor.
couple courts we can
I'll
jump
call
to.
court services as soon as we're done here, make sure they're aware of it and how to reach him.
It's going to get a little noisy here, but let me show you what's
We've
happening
got
right now.
the contact information for the correctional facility if they.
Let's just wait till we get finished this morning and see if we can find Ms. Brown, but if not, we'll bring it back this afternoon.
Judge Clark. Judge Clark's doing felony appearances here.
Yes, sir, I know Mr. Cat. Good morning. Good morning.
Burnett is live. Ooh, let's bring in Burnett as well. Bring in Burnett on 3.
All right. Good morning. This is State of Florida versus Dakota Cat, 25 CF 2340. And I think also has 24 CF 3049, which should be a violation of probation. We're here today on a motion to suppress. And Mr. Cat is, Mr. Ballock's filed on behalf of Mr. Cat, and the state has responded. Thank you. All right. You too, Mr. Meredith. Thank you. Ms. Beasley, you have a good weekend too. All right. See, this is, the state concede they have the burden? Yes. Okay.
State called John Gay.
Mr. Gay, come on up. Hush. Now I'm trying to have court. You don't raise your voice.
Yes, ma'am. Morning. Say your name for the record, please. John Dalbrigade Jr. And where do you work? The Panama City Police Department. How long have you worked there? Since May 2023. What are your current duties? I'm a detective with the Street Crimes Unit. How long have you been in Street Crimes? Approximately a year. What's the role of the Street Crimes Unit? Mostly narcotics, drugs, prostitution, vice crimes, etc. So you're part of the drug unit for the city? Yes, sir. As part of your training, are you trained to detect the odor of marijuana? Yes, sir. Were you working on July the 29th, 2025? Yes, sir. All right, now, you arrived there and were you involved in a different arrest, 261 Everett Avenue? Yes, sir. And that's the Henry Clerking Apartments? Yes, sir. Now, about that area, have you in your experience done drug arrests in that apartment complex before? Absolutely. All right, so would you consider that a high crime area and specifically about narcotics? I would. Now, so you're involved in this other arrest of someone else. How did you first come into contact with the defendant, Dakota Cat? We were currently investigating another drug offense in the parking lot of Henry Kirkland. While talking to him, Dakota Cat exited an apartment nearby. As soon as he saw us, he started making furtive movements, tucking stuff in his pants, and he walked right beside us. His person smelled of marijuana, and we made contact with him at his vehicle, and obviously his vehicle. Yeah, we'll get there. So he walks by you. How does he look? Nervous. He looks nervous. And then he goes, where does he go? Straight to his vehicle. And what do you do? Well, I made contact with him at his vehicle. All right, and what happened when you approached the vehicle? As myself and Detective Shaver were approaching his vehicle, he tried to rapidly start it and leave. We exited our vehicle, made contact with him at his driver door. I tried to ask him to get out of the car. His car smelled like marijuana. He instantly began resisting, wouldn't let go of the steering wheel. We had to force him out of his vehicle. Now, at the time that he got into the car, did you see him doing anything in the car? Yes, sir. He would, when he sat in his car, as we were making contact with him, he was also still trying to mess with his pants, just sticking stuff in his pants. And did that cause you any concerns? Yes, sir. It's a big officer safety concern, possibly destruction of evidence or concealing evidence, etc. So two concerns there: potential for officer safety and potential of destruction of evidence. Yes, sir. And you asked him to get out of the car? Yes, sir. Were you wearing your police gear? I was. So you were clearly marked as a police officer? Yes, sir. And he didn't comply with any of your orders to get out of the car. You had to physically remove him from the vehicle. Correct. Did you search the defendant? Yes, sir. Did you find something? Yes, sir. What'd you find? He had a $20 bill that was folded multiple times. It had a substance inside of it that field tested positive for fentanyl. And in your experience, that fold, is that indicative of anything? Yes, sir. It's common with street level narcotics. So you had a substance tested positive for fentanyl? Yes, sir. Did you then search the car? Yes, sir. What'd you find in the car? Ammunition and marijuana. And you then found out that Mr. Cat is a convicted felon? Correct. And we're not allowed to have that ammunition? Correct. No further questions?
About your witness.
Okay, you said that you were investigating a separate issue at this time, correct?
Correct.
How long were you on scene for that?
20 minutes.
Okay. And was that at all related to Mr. Cat?
Yes, sir.
That investigation was related to Mr. Cat?
Yes, sir.
How's that?
What we were investigating is we got out with somebody in the parking lot of Henry Kirkland Apartments, had fentanyl paraphernalia in plain view inside his vehicle. That individual later provided a sworn recorded statement that Dakota Cat did sell him the fentanyl from his apartment. And Dakota Cat was later interviewed at the Panama City Police Department in reference to that.
This all happened after this encounter though, right?
No.
This happened prior to?
Yes.
How soon before?
Minutes.
So minutes before they gave a sworn statement that Mr. Cat was involved?
Correct.
And that's an investigative report that you?
Not mine, the Corporal Porter.
Reporter?
Corporal Porter, P-O-R-T-E-R.
Okay. So you said that it smelled like weed. How close did you get to Mr. Cat?
When he walked by us?
Yeah.
Feet.
And what type of day was it? Was it dark out? Was it light?
Clear sunny skies, 5 o'clock in the afternoon.
Okay. Was it windy?
Not very.
You said in your report that you smelled burnt marijuana, or was it regular marijuana odor?
Marijuana.
Is there a difference between burnt or regular?
To some people.
What about to you?
Not really.
Did you smell burnt or regular marijuana?
I smelled marijuana.
Okay. Was there any?
I want to know, is it burnt or green marijuana? I mean, that's a question I'd like to put in the answer.
Burnt.
Okay. Was there any indicators that would suggest that there was marijuana being burnt? Was there any smoke coming off this person?
While he was walking, no, sir.
Okay. Was he holding a joint or a blunt?
No, sir.
Did he toss anything in your presence?
No, sir, but he was messing with his pants.
Okay. Is that in itself Criminal?
What?
Criminal in nature to tuck in his shirt or put things in his pockets?
Yeah, it can be, yes.
Okay, so it could be innocent.
What's the
but in
code?
this situation, you saw it as criminal.
Let's hold on just a second. Whoever's out there
It's me, Judge.
making the noise, y'all need to be quiet. If
Sorry.
you can't be quiet, leave the courtroom.
Sorry. Hush. Trying to hold court.
Hush. Now I'm trying to have.
And you didn't see any observable evidence to suggest that he had a burning piece of marijuana on his person, right?
Correct.
Okay, so all you smelt was what you thought was an odor coming from his person.
Correct.
Okay. You don't stop him right then, though, right?
No, sir.
Okay, you get in your car and you drive to his car, right?
Correct.
He's in his car when you pull up and you block him in, right?
Correct.
So he was unable to move.
Correct.
Was there any indicators that the car was turned on?
When
Did the
I
lights
was,
illuminate in Mr. Cat's car?
no, I could hear the ignition.
Was it a push to start or a key turn?
It was a key.
I think I'm.
Okay, so you're in your car driving up and you can hear the car starting.
No, sir. It started when we exited our vehicle.
Okay, so you exit the vehicle and you're approaching his car.
Correct.
And you're saying that he tried to start the car then?
Correct.
Was he under arrest at that point?
No, he was detained at that point, or preparing to be detained.
Did you give any lawful orders prior to that?
Prior to
pulling up?
No,
As
sir.
he passed you, did you say, hey, stop?
No, sir. I didn't make contact with him until I pulled up to him.
Okay, so he passes by you, he puts something in his pocket, he tucks his shirt in, and you see that as indicators of criminal activity?
Yes, sir.
You walk up and within 6 seconds, you get him out of the car, right?
I don't know how long it took.
Did he open the car or did you open the car door?
I did.
So you walk up after blocking him in and immediately order him out and open the car door.
Correct.
Did you give him any chance to comply?
Yes.
Did you say open the door?
I said step out of the car, open the door, and then myself and Detective Shaver ordered him multiple times to step out of the vehicle, to which he did not.
At this point, does he have to turn the car off?
No.
Because it's not on.
What do you mean?
The car at this point is not on, right?
No, he couldn't start it. The ignition was just turning.
Okay. And you saw that as evidence of him trying to flee?
Trying to not follow orders, yes, sir.
Okay, but at this point, he doesn't even know that he's being arrested or detained or anything, right?
No, he did. He was being told.
Through the glass in the car?
No, the door was open.
Okay. So it's your position that he was fleeing by trying to start the car?
I didn't say that he was fleeing.
So he was never fleeing?
No, sir.
Did you find any marijuana on his person when you did search him?
No, sir.
And when you did field test the remnants or the residue on the dollar bill, you said it came back to be fentanyl?
Yes, sir.
And was it later lab tested?
I believe so.
And did it come back not fentanyl?
I did not get the results of those. It wasn't.
If I were to show you, could you confirm it was or wasn't?
No controlled substance.
So what you presume to be criminal activity later was understood to not be, right?
I don't fully disagree with that, or wholly agree with that.
Felt like marijuana, but you found no marijuana in his person, correct?
No, sir, just in his vehicle.
And then what you thought was fentanyl on his person ended up not being fentanyl, correct?
Correct.
Would you agree that positioning your car in front of his made it impossible for him to be evasive or to flee?
Yes.
Did you ever ask him if he had a med card?
No, sir.
And where was the marijuana found in the car?
In the rear seat of his vehicle,
Okay, so not in the front seat or the passenger seat.
in the rear seat.
Okay, was it in a box or anything?
Not sure, it was just a joint.
Was it already lit?
It had been burnt previously.
How far would you say that you traveled from where your car was parked to get to where Mr. Cat was?
25, 30 yards.
I told you it took you 16 seconds to get there. Would that be somewhat accurate?
Sure.
Okay. So it takes you 16 seconds to get to his car, and that you're saying that all the while driving over there, you were able to see through your glass and his glass him doing movements in the car?
Yes, sir.
Your view wasn't obstructed at all?
No, sir.
Did Mr. Cat ever ask you why he was being stopped?
Yeah, multiple times. I told him that he was being detained for a lawful reason.
And what was that reason?
The odor of marijuana and the sworn statement collected from the individual.
I don't think I have any further questions for him, Your Honor.
Any redirect?
Just briefly, there was ammunition in his vehicle.
Correct.
And he was placed under arrest for being a felon in possession of ammunition.
Yes, sir.
Any other questions?
No.
Can the witness be excused?
Yes, sir.
So you may go about your day.
Thanks, sir.
Call your next witness.
That's all I have, Your Honor.
All right. Anything else?
Just like to add some closing argument, Your Honor.
Sure.
It's the state's position, there's the defense's position that the state has mischaracterized this as a detention that escalated. And it's our position that it was a detention from the start that's unsupported by objective facts, and the state attempts to justify it with facts learned afterwards. I believe that they cite several cases as controlling in this case. The first one is Mims, and we believe that the facts in this are distinguishable from Mims because in Mims, it's a Supreme Court decision where the defendant was driving erratic, or he was driving on an expired tag. They pulled him over, they asked him to come out, and they had lawful reason to do so because he was being detained for breaking the law. This is distinguishable here because Mr. Cat was not driving. He was not breaking the law in any way. There are weak facts that the state stacks to make it seem like there's a stronger, compelling argument for why the justification was for detaining him. But it's our position that those weak facts don't automatically become strong facts just because you have a lot of them. It's our position that when taking the totality of the circumstance, deferred movements are tucking in his shirt and putting his hands in his pockets, moving his hands around in the car. He could have been using his cell phone, generic nervousness, and then vague officer conclusions. We don't believe that that's taking this in the totality of the circumstances, create objective facts to prove that unlawful activity was taking place. And to go even further, the state then cites the first DCA opinion from Hatcher. This is distinguishable from that case as well, because in that case, the defendant was driving at 3 a.m. He was driving erratically. When he gets pulled over, he admits, I just smoked a blunt, I just threw it out. He makes admissions, and then it's later determined that he was at a no valid driver's license. So they had the basis to determine that the detention was lawful based on objective, articulable facts in the case. In this case, he wasn't driving, he wasn't acting erratically, and the officer even admitted that the basis for it was not that he was fleeing or eluding, as the state contends in their response to our position. It's the state's position that we mischaracterized this stop as it beginning when the odor was detected, and that the stop actually happened when he was trying to flee. It's the officer's position that he was never trying to flee. the officer put his car in a position where it was impossible for Mr. Cat to flee. And then there's no objectable facts to prove that he was doing anything unlawful aside from just smelling like marijuana. And I mean, we're talking about an open area in the middle of the day in a known crime area where they're saying that it came from him and not from somewhere else in the area. I think that those are weak arguments. We also rely on Kilburn, where it's another DCA opinion, their first DCA opinion. In that case, the court found that innocent behavior, in that case, the facts are that there was a gun in plain view, that they said that's an unlawful activity. But the court determined, no, that's actually not unlawful and not criminal activity, because you can have a legal gun, and just seeing the gun is not evidence of criminal activity. In this case, we argue that the weed smell alone is akin to the observation of a firearm in the vehicle. That just because he smells like marijuana doesn't mean that he's committing an unlawful act. They never asked if he had a med card. They never asked if he was in lawful possession of marijuana. They just assumed that because he was in a high crime area, that he somewhat smelled like marijuana, even though he testified wasn't burnt marijuana, it was the odor of marijuana, that does not justify breaking his Fourth Amendment by protections. It's our contention that the basis for the stop was for the smell of marijuana and not for fleeing. There was no lawful detainer. He was never told that he was under arrest. And moreover, Your Honor, I'll just write down. It's our position that that there was no lawful stop here, that MIMS, though it's reference to them, it presupposes that a lawful detention was taken, had occurred, and that the issue here is that there's no basis for the detention of the defendant. And then Hatcher, it shows independent facts that created an issue before there was an escalation. We believe that the officers in this case escalated this situation, and that here it is. We believe that, Your Honor, because there was no marijuana on this person, and because the fentanyl tested, the suspected fentanyl ended up not being a controlled substance, it's our position that the state is in the wrong for continuing to prosecute Mr. Cat, and that rather than admitting it, we now have to prove why this whole thing never should have happened the way it did. Your Honor, it's our position that Mr. Cat was acting lawfully on this date, and that he was detained without objective facts to establish he was creating or doing anything unlawful, and the officer is unable to articulate a valid reason to detain him. It was the state's position said, no, actually he wasn't. On just the smell of marijuana, I believe that they're violating his protections by using that as the sole basis to detain him and then further search.
Yes, Your Honor. A few things. I think Mr. Ballack suffers from a case of selective amnesia, starting with the fact that he puts in footnote number 1 of his motion that he accepts all of the facts of the state as undisputed, but then comes here and wants to challenge all of the facts. So I'm not sure if he wants to have his cake graded too, if the facts of the state's alleging are undisputed.
Objection.
And then he comes in here and challenges those facts. So one way or another. He's also missing one of the things that he elicited today, which I had not written in my response, but there was an informant who pointed directly to Mr. Cat as the person who had sold him the fentanyl. So it's not just the basis of marijuana alone. Mr. Ballack seems to forget that they had information about Mr. Cat selling fentanyl. They find a substance that field tests positive for fentanyl. It doesn't matter that it later wasn't anything. And I'm not prosecuting him for the possession of fentanyl anymore. We're prosecuting him for being a felon in possession of ammunition. So the later field test or the later test doesn't matter at this point. What matters is they were justified at that point in time because they had the field test, which allowed them to search the car and find the ammunition. We had an encounter here that was escalated over time. So, and each of the steps, they were allowed to do what they did, right? So they were allowed to approach him the way that they did because they had information about him and his appearance and his furtive movements. There's been no testimony about tucking in a shirt. I don't care how many times Mr. Ballack has to say that, right? He's the one who's saying he was tucking in his shirt. And then in the car, those furtive movements, and that allowed him to ask him to get out of the car. They search him, then he refuses, which then puts him under arrest at that point and being detained. The search of his person yields the fentanyl, which allows him to get into the car. So at each of the steps here, law enforcement followed what needed to occur. And again, missing and forgetting about certain inconvenient facts doesn't make it so.
I'll take it under advisement. We'll set this. No, we're not set for trial.
I like to set this for an evidentiary hearing. That's where this will end up. Yes.
Yeah, let's set it for March 25th at 1:30 and 9 o'clock. Now I have an order on this motion to suppress prior to that. Okay.
So we won't get an answer to that right now.
Yeah, well, not something that's really. Unless you want to be placed under oath and be subject to cross-examination, no, sir.
Attorney should say be quiet.
Mr. Cat, just have a seat. You weren't called as a witness. You want to be called, if your attorney wanted to call you as a witness, you'd have to be sworn and give testimony. So have a
Ma'am,
seat.
you can leave. Now, thought about her. You need to leave right now.
Your Honor, if we could just reopen it.
Both y'all can leave.
You might want to talk to him. I mean, because he's going to be subject to cross-examination and everything else. Mr. Cat, just have a seat.
Yes, sir.
Whoa, Judge, I think you might be out of line there.
The only other one I have is with Mr. Solomon. We're waiting for him to get back from sentencing.
Which one is that?
Foster.
I think the
What are we doing on
judge
Foster? What is that?
was out of line. He said, if you want to talk, you have to be placed under oath. He says, we'd like to do that. The judge says, you need to sit down. Uh-oh.
All right, well, I got some, let's see, Ms. Downey, you want to call your case for this afternoon? Go ahead. And then I've got some pro se's I'll call. And we have heard from Ms. Brown yet?
I emailed her about showing up via Zoom this morning after we spoke about it, and I haven't gotten a response from
I
her.
don't think Ms. Nelson has either. All right, Ms. Downey, go ahead.
Thank you, Your Honor. This afternoon, we have State versus Brian Williams, 24-35-23 CFMA. And Your Honor, Mr. Williams is on the jury trial scheduled for May 3rd. And we are
March
prepared.
2nd.
I'm sorry, March. Why do I do that? May and March? I have 0303. And we are ready to proceed. I understand that's a full docket. I think this is going to be a super short case.
You want to keep it on the docket for a backup?
We can, Your Honor.
Let's keep it on the docket. If we can try that week, we'll try it.
We would love that. He would like to get this resolved and behind him.
Okay. All right, March 2nd at 8:30.
Okay. Thank you, Your Honor.
Yes, ma'am.
Be ready back.
All right, let's call Sue.
Would you like to do John Clark in this statement?
Yeah, John Clark. Mr. Clark?
Your Honor, just for the record, I did let him know I'd be handling it this morning.
Okay, good. Thank you, Ms. Downey.
As long as you were okay.
I'm fine with it.
Okay.
All right.
It's a fantastic.
Mr. Clark, you're representing yourself. Do you wish to continue to represent yourself?
Yes, sir.
All right, you may proceed. And I've reviewed your pro se motion for statement of particulars and the state's response.
Sir, this is the first time I'm seeing it, so I would like an opportunity to review that and, just to let the court know that I was acting under the directive of the court. I have court order and we returned all notices from the court in the foreclosure as deceased. And from my understanding, once
I got no idea what you're saying. I don't know what you're talking about.
and the foreclosure,
I got no idea what foreclosure you're talking about.
Well,
I don't know anything about this case except what's in the state file. I don't know about a foreclosure. I know nothing about it, Mr. Clark.
all right,
Not
sir.
one single thing.
I was arrested for resisting arrest during a writ, and after that writ, I was ordered back to the residence, and 7 days later, arrested for burglary. I had no idea I was doing anything wrong. I was acting under the court's directive.
You're not acting under this court's directive.
No, sir, it was the court.
Make that clear.
Yes, sir. I was acting under the pretrial release order, ordering me not to change my residence.
But Your Honor, the defendant was.
Oh, no. That argument is not going to. Are you saying that you were evicted or from a residence, and that's the residence you gave down on a? Explain your argument real quick.
I didn't give any address. They just court ordered me.
Who court ordered? What court order are you talking about? Can you do that too? Is that a pretrial release?
Yes, sir, from the misdemeanor. I mean,
oh man,
I had no way of knowing I was doing anything wrong. All the bills and everything were still in my mother's name.
I guess that's what we're arguing about is that, but I don't know what you're talking about. So,
I mean,
you're here today on a statement of particulars. You want a chance to review the state's response?
Yes, sir.
All right, I'll give you to March 27th at 9 o'clock.
All right, thank you.
I've never seen this judge quite in this much of a mood.
You can. I don't know if I can answer or not.
That's the correct address?
Yes, sir.
All right, sign name and phone number.
All right, that's okay. All right, let's call Hernandez real quick. State via Richard Hernandez. Come on up, sir. All right, Mr. Hernandez, you're before the court today. You're representing yourself. Do you wish to continue to represent yourself?
This court's in Florida.
All right, we're set for motions this morning. What motions would you want to hear?
Motion of particulars I've never received. I've never received any videos from the law enforcement, from their body cams or their vehicles or the witness. Then the video that I did get from them was from a third party 911 call, and then 4 videos that from other people's cases that I don't even know who they are. They just on my DVD.
Did you get a DVD?
Yes, yes. They allowed me to view it. I've got the names of the people that are on that DVD.
You're indicating it has nothing to do with your case?
No, they're 4 different cases. One's a family law case. One's an arrest from Panama City Police Department arresting 2 people in a Chrysler, and then there's 2 other cases of. I've got their names here. And they even gave me Social Security numbers and everything on the Bay County Jail.
Direct somebody to go out there?
No, Your Honor, I don't know what is referring to, and I don't know what family law stuff. Even I wouldn't have provided any family law stuff.
It's all on there. I mean, I've got it.
I think I'm about to catch a whooping.
Here it is. Okay, one was Duval and Cloud, which was Michael Overstreet was the judge there involved in that one. and Mrs. Cloud was there. And then another one was Ivy Cohen, case number 2021-046924.
Recognize
The
that.
other one was Tyrone Irvin, 2021.
When did you showed it?
This was probably 2 weeks ago.
I don't recognize any of those names. They're not associated in any cases I'm prosecuting, Judge. I don't know what he would have been shown or why.
The only, on top of that was just a 911 call from this case, which it had, somebody else.
Is there any other videos or anything that is discoverable?
There may be body cam, Judge. If there is, he'll have to request that directly from the agency itself. Beyond that, all the discovery's been provided.
Who's the arresting agency?
Panama City Beach Police.
Who came out this? Who did you review? Who reviewed that information with you?
It was the classification officer, Williams.
Okay, it was somebody who was an employee of the jail.
I had to put a request in to be able to see it. But
what agency did it come from?
It came from their office right after the court when I had asked for that I hadn't received my discovery. It's been past the time limit. And right after I got back from court, they called me and handed me this paperwork I've got in front of me. And then
that paperwork, is that the discovery right there?
the DVD. Yes.
There's a response that was filed on January 22nd from the state.
I haven't.
Yeah, this is the discovery. But if he was called in right after court, I wouldn't have had time to go back to my office, run a disc, and get it out to the jail. Like whatever they showed him would have been out there prior to. I don't know what he was shown.
It was received right then and there. I mean, I had to sign for it from.
I'm not saying.
Yeah.
I'm not saying. I'm just saying. I don't know what it is.
Mm-hmm.
They showed him the wrong
body
disc.
cam. You have to on that body cam.
There's one body cam video on that from not even my case.
If there's body cam on your case, you have to request that directly from the Panama City Beach Police Department.
Mm-hmm.
Do you want to do that?
Yes, please.
Okay. Well, you need to do that yourself. I can't help you do that.
Okay.
All right. So you'll have to file the paperwork, or file the response, or file the request to the beach. Okay. I'll set this for March 27th to see where we're at on that. Anything else?
Like I said, statement of particulars, and then
you reviewed that.
I don't know that I was served. I've not seen it, Judge.
There's one in the file. Have you served that with the state, Mr. Hernandez?
Yes.
There's a pro se motion for statement of particulars, pro se motion demand for discovery, pro se motion for adversarial preliminary hearing.
Mm-hmm.
Do you have any of those?
I see them in benchmark. I don't know that I got copies of them, but I can pull them up here. As far as the motion for statement of particulars, our response would be, Judge, that the information and the discovery provided to the defendant is sufficient. It appears, Judge, that he was arrested on 9/22 and
information was filed on October 9th.
Yes, which would be under the 21 days. So I would ask that the motion for adversary preliminary hearing be denied as well.
Good attempt, sir, but
I'll do that. I'm going to deny those based on that time period. And there's a motion to set bond. His bond does need to be adjusted, it appears. He's got maybe not.
It may, Judge.
There's $100,000 on kidnapping. You didn't file kidnapping.
I did not file. I filed false imprisonment.
All right, that kidnapping will come off.
Kidnapping.
So that's $100,000 that will be removed. If he's called with false imprisonment, tampering with a witness, and resisting officer without violence, so his bond will be $10,000, $15,000, $16,000. So your bond's going to go down from 120, 125, 127 to $16,000. Okay. We'll leave it on March 27th at 9 o'clock. and for you to request that information from the Beach Police Department, okay?
Okay.
All right. Anything else?
To be able to get my my wallet with my bank card and all my,
As you're going to have to do that with the jail. I don't have any,
well,
it's
it's over at the Ark where I was living at.
Yeah, I got no control over that. All right. That'll conclude the hearing. Good luck, sir.
All right, thank you, sir.
All right. Is Mr. Ballack ready on Mr. Foster? What do you got? Mr. Nelson, any word from Ms. Brown?
No, sir.
Okay.
Judge says he's done. He's all done. All right, it's 12:07. We're waiting for anything exciting to happen. They're popping around court to see what's up. Burnett has been live. We can jump in on Burnett, actually. Where's Burnett? Right there. Why are we having a staring contest? Clearly have an officer on the stand as a witness.
Did you go to the hospital for the blood draw?
No, I did not.
Sounds like a DUI.
So after Deputy Mangan left the Gandy Dancer with Mr. Brown, did you ever see Mr. Brown again that night?
The Gandy Dancer? Is that a bar?
How long were you at the Gandy Dancer once you arrived?
I don't know an exact time. I would probably estimate about 10 minutes.
We have to back up 10 minutes, says Josh. Josh says, back it up. Back it up, back it in, and let me begin. I came to get down. Okay, there we go. 10 minutes right here.
Swear that the testimony you're about to provide today in this matter is the truth, the whole truth, and nothing but the truth.
Yes.
Yeah, officer's taking the stand. Jump up, and get down. We're going to speed it up to 1.25 because they appear to be in slow mode today.
Can you please state and spell your name for the record?
Gavin Anton, Gavyn Anton.
Excuse me, is there a squeal coming out of something?
Oh, that was me,
I don't
Judge.
hear a squeal.
You heard?
I don't hear a squeal.
I hear air. We're off the record. I hear air coming out of there, but I don't hear.
I squeaked my boots off the.
The what?
I squeaked my boots off the chair. It might have been.
No, it was a squeal that I could. I can't hear it.
Okay, back on the record.
How are you currently employed?
I'm employed with the Burnett County Sheriff's Office.
And how long have you so been employed?
A little more than 2 years.
Prior to today's hearing, did you review a criminal complaint in Burnett County case number 25 CF165 as it relates to Mr. Jeremy Brown?
I did.
On November 22nd, 2025, did Deputy Bailey Mangan attempt to conduct a traffic stop near County Road U in the Oakland Township?
Yes.
Is that area located in Burnett County?
It is.
Why did Deputy Bailey Mangan attempt the traffic stop?
Deputy Mangan observed a Ford F-150 pickup truck where the passenger tires both left the roadway on the right side. And as Deputy Mangan was turning around, the truck crossed the center line. It was in the opposing lane of travel.
They're meant to go.
Did the vehicle ever stop?
Eventually it did, yes.
Where did it stop?
At the Gandy Dancer Saloon.
Is that area located in Burnett County?
Yes.
Did Deputy Mangan make contact with the driver?
Yes.
Who was the driver?
Driver was identified as Jeremy Brown.
And how was he identified?
Deputy Mangan recognized him from previous contacts, and the truck was also registered to Mr. Brown.
Understood. Were you present when Deputy Mangan made contact with this Jeremy Brown?
I was present about halfway through Deputy Mangan's contact.
So you did see Mr. Jeremy Brown on the scene?
Yes.
Do you see that same Jeremy Brown here in the courtroom today?
Yes.
Could you please identify him by where he is sitting and what he's wearing?
Yes, he is sitting to my right wearing a white and black quarter zip.
Let the record reflect that Deputy Antone has identified Mr. Brown.
Did Deputy Mangan speak to Mr. Jeremy Brown?
He did, yes.
What did they talk about?
Deputy Mangan advised Mr. Brown the reason for the stop. And throughout that contact, Deputy Mangan noted that he could smell the odor of alcohol coming from Mr. Brown, and also observed slurred speech and glossy eyes.
Understood. Did they talk about anything else?
They talked about the reason for the stop. Mr. Brown stated that he and an unidentified passenger at the time had switched seats after Deputy Mangan had activated his emergency lights.
Understood. Did they talk to anything else about the switching of the seats?
Deputy Mangan asked them how they switched seats, which was not talked about, and why they would switch seats, which I don't think there's ever an answer to that either.
Understood. Did you make contact with this passenger that supposedly switched seats with Mr. Brown?
Yes.
Who was the passenger?
The passenger did not want to identify himself to me, and he was his first name was eventually found out to be Bennett.
Did you discuss anything with this individual?
Yes, I asked Bennett if he had been driving, to which he stated he had not.
Understood. Did Deputy Mangan conduct any testing with Mr. Jeremy Brown?
Yes.
What kind of testing?
Deputy Mangan asked Mr. Brown if he would do standardized field sobriety tests. Mr. Brown refused testing, but consented to the preliminary breath test, which the result was 0.170.
Were there any other testing conducted?
Yes, a blood draw was eventually conducted later on.
What were the results of that test?
The results of that test was...
Objection irrelevant for today's purposes. Oh, withdrawn.
All right, you may answer.
The result was 0.235 gallons per 110 milliliters of ethanol.
Understood. Was the defendant placed under arrest as a result of this incident?
Yes.
What was he arrested for?
It was OWI 4th, failure to install IID and operating after revocation due to alcohol.
So when you say OWI 4th, does the defendant have prior OWI convictions on his record?
Yes, he has 3.
No further questions, Your Honor. And the state will eventually move to admit the defendant's driving record into evidence. Sorry, the state will also move to admit the defendant's driving record into evidence.
Right.
Blame it all on my roots.
You can look at it.
I showed up in boots.
Okay. All right. Thank you.
Ruined your black
Look at it.
tie affair.
Okay.
Pilot. All right.
Gonna get
Questions, Mr.
copyright
Anderson?
Yes, Judge, thank you. Deputy Anton, did you ever see the F-150 moving on a highway of the state of Wisconsin?
I did not know.
And where did you come from as far as when you received a dispatch that Deputy Mangan had someone stopped?
I was north of County Road U on State Road 35, approximately 2 miles north.
All right, and then, so you had to, which way were you proceeding?
I was coming south.
And then, so you proceed 2 miles south. Did you activate your emergency equipment?
I did at one point, yes.
Do you know when?
Deputy Mangan called out the traffic stop and said he had somebody walking into the bar and was not listening to him. So that's when I activated my emergency equipment.
Okay. And once you get to Highway U, I assume you turn to west.
Correct, yes.
And Highway U is a 2-lane county road?
Yes.
And how long did it take you to get from the intersection of U and 35 to the Gandy Dancer Saloon?
Minute and a half.
So from the time you heard the dispatch, how long did it take you to get to the Gandy?
Oh,
Gandy Dancer Saloon.
5 minutes in there somewhere.
All right, thank you.
This one could be interesting.
Now,
never saw him driving on the road, but man, 0.32.
Where did you first see Mr. Brown?
You said,
I saw Mr. Brown. He was standing next to Deputy Mangan in front of Deputy Mangan's squad.
But you'll never hear me complain. It's a good song.
And from Deputy Mangan, did you learn that Mr. Brown had already gone into the Gandy Dancer Saloon and came back out?
Yes.
Did you ever notice Mr. Brown's speech being slurred?
Yes,
You did?
I did. I did stand next to Mr. Brown while Deputy Mango was talking to him. Yes,
Okay. And were you able
Did
to
you write it in
observe
your
glossy
report?
eyes?
I did.
Glossy eyes, slurred speech. 2 Ford
And
wheels off
did you
the road.
hear Mr. Brown deny being the driver?
Yes.
This is Florida. We're in the Panhandle. Oh, sorry, this is Wisconsin. We left Florida. This guy's Panhandle.
Not give a final.
We left him. We're back. We're up in the northern country, the Arctic, north of the great US of A, below Canada.
Did you go to the hospital for the blood draw?
No, I did not.
So after Deputy Mangan left the Gandy Dancer with Mr. Brown, did you ever see Mr. Brown again that night?
No.
How long were you at the Gandy Dancer once you arrived?
I don't know an exact time. I would probably estimate about 10 minutes.
Need to add 5 more sneezes to the counter.
This person you spoke to named Bennett, can you describe him as far as his height and weight?
I would describe him as about 5'6", 5'7", and 220 pounds, about 65 years old.
No further questions for today.
All right, redirect.
Just a few, Your Honor. So Deputy Bailey Mangan was the one that observed the Ford F-150 driving on a highway in this county, correct? Yes. And upon arriving at the Gandy Dancer Saloon, Deputy Mangan is the one that saw someone matching Mr. Brown's description exit the driver's side, correct? Yes. When you did make contact with this passenger named Bennett, was he sitting or was he standing? He was sitting in the front passenger seat. So he had the door closed and you just got a little bit of a glimpse of him? Correct. No further questions, Your Honor.
Any redirect?
Nothing
Or
else,
recross?
Judge.
Sorry. All right. You're free to step down. Thank you. You are released. Any further witnesses?
No, Your Honor.
Witnesses today?
Excellent. Thank you. Based upon the information and testimony that the court has heard from Deputy Gavin Antone, the court will find that there is reason to believe or that a felony was probably committed and was probably committed by Mr. Brown in Burnett County. The court will find probable cause and will bind the matter over. Information, Mr. Vila?
Thank you, Your Honor. I'm going through and filing the information as we speak. It will mirror the criminal complaint.
Would you like to proceed with an arraignment or set for another date?
I would like to have that set for another date.
All righty. I can do March 4th at 10. And video conference Zoom is fine. Does that pen work, Mr. Brown?
Oh, yes, ma'am, it does.
Okay, thank you.
I guess I didn't check it.
I've been told it wasn't working and I need to order a new one. I need to write that on a list.
March 4th at 10 will work.
Excellent. March 4th at 10. Again, Zoom is approved. Are you still on Howe Road?
Yes, ma'am.
Telephone ends in 8185.
Yes, Your Honor.
We're good to go. You can come up here and you will get a written notice.
Okay.
So you can write it all down, do what you want to, but you can get a printed notice here as well. If there's nothing further, we are adjourned.
Thank you.
And the judge just turns it off. We're going to jump back to Judge Clark. He's back.
Not moved. And based on the testimony in reference to your training reports, she was never rewarded for any of those actions during the training while she was in your care, correct?
She was rewarded at the alert, but she had all those indicators leading up to the alert and was rewarded for all of that.
Correct. But I'm asking, at no point in any of her training was she ever rewarded for head snapping, closing her mouth, or staying in a place for too long?
She was rewarded for that, as well as the sit.
On what day did that happen? I just ran through.
You ran through all of them, and she was rewarded at the sit, but she was rewarded for all the indicators leading up to the sit.
There was also times when she would not and you didn't reward her.
Correct, because we're training at a known source.
Should Molly behave as she's trained to do in the field, or does she have free will to do anything she wants in the field?
She should behave as she's trained, yes.
Is it your belief that sitting provides probable cause to then search the car? An alert provides probable cause?
Yes.
Any further questions?
Yes, I know this is gonna sound like a stupid question, but when you run your dog can't just speak up and tell you, hey, I smell drugs, can it?
Correct.
So when you do your training, you're training the dog in a way to communicate to you that it smells drugs.
Yes.
Correct? But as a canine handler, you're able to watch and observe these behavior changes that also indicate, short of that communication, that the dog smells drugs.
Yes.
And in this particular case, drugs were also found in the vehicle based off of the search that was conducted.
Correct. 110 grams.
So the dog's senses in this particular case were accurate.
Yes.
Your observation of the dog's behavior changes were accurate.
Yes.
Have you taken your dog and run the dog before and not noticed any of these behavior changes?
Yes.
No further questions, John.
Any other questions?
Are you a dog whisperer?
No.
Anything else for this witness?
No, Your Honor.
He be excused.
Yes, Your Honor.
Or you may go about your day. Any other witnesses?
No, Your Honor.
Any argument?
Yes, Your Honor. The fact that he's not a dog whisperer is exactly why he watches and observes the behavior changes. I'd also, just as far as argument goes, Judge, this is the exact same issue that Mr. Valak asked you to reconsider in the Maurice Bennett case yesterday. So as far as the case law goes, Your Honor's already done the research, knows the law. I would ask that you just essentially repurpose that order because it's the exact same situation as this case.
Anything else?
Yes, Your Honor. I would contend that it is the exact same situation. And in your analysis, you note that I believe it was the Prada argument that you explained that there are indicators that lead to an alert. Or no, there's alerts that lead to an indicator that it indicates where the presence of the narcotics are found. However, in the training logs, it does the reverse logic. It says that it needs indicators to get to the alert. At no point in the training logs is he ever rewarded for changes in behaviors. He was never rewarded for a head snap. He was never rewarded for a closed mouth or staying for too long. The question is, did the canine alert the officer? And if he did alert it, that provides probable cause. It's our contention that an alert is a term of art. It's not alerting, alerted. It's not an interchangeable word. The officer only gets probable cause when the dog comes out and alerts the officers to the presence of narcotics potentially being in the vehicle. I agree that the state's trying to use the dog whisperer argument against me, but how do we know what the dog is trying to convey if it doesn't do what it was trained to do? The officer Casey handled the canine around the vehicle multiple times and had every opportunity to provide the officer with probable cause by sitting, and it never did that. It's undisputed that Molly never sat. If the dog doesn't sit, then the dog does not.
You must acquit.
Objectively,
if the dog doesn't sit, you must
acquit
acquit.
To the presence of narcotics. The Prada argument is that the dog is always alerting. It's alerting by changing behavior, and that it indicates the presence of narcotics. But the training logs say the opposite. It says that it indicates a potential odor of narcotics through changes in behavior, but it never alerts until it sits. Okay. So unless the dog sat, it never provided the probable cause.
Very good. All right, I'll take it under advisement.
Come on, Judge, make a ruling today.
The case.
Remember we could put the training logs in the vault list?
What?
The vault list.
In the evidence. Any objection? They'll be marked as defendant's exhibit number 1.
Training logs are going in the evidence list.
Question for the where we're at posturally in the case. I believe we've already done depositions. We'd asked if you did find a motion, and then we discussed entering a plea.
It was
and-
probably
March 26th.
one of the most eloquent anti-drug dog arguments I've heard.
Motion, I have a water hot.
Thank you.
All right, thank y'all. All right. That's all we've got this morning. We've got this, Alistair, we got a couple this afternoon. Is Mr. Overstreet gonna be here or somebody covering for him? All right.
Thank you.
Yes, sir. Mr. Ballard, have a good weekend.
Yeah, I'll have a good weekend.
Got two, we got, Nita Johnson and,
I think Mr. Overstreet was expecting.
well, I saw Mr. Peacock, but he must have got tied up somewhere. We also got Mr. McCarthy has one. Doesn't she?
And I think Stan forgot, because I saw.
He may have.
We're going to jump back up to Burnett, current live, see what's happening here.
I am so proud of you, Ms. Benjamin. Look at where you are right now. Look at what you're doing. You have your girls back with you. You're raising your new baby. You are looking at additional school. You are sober, and you are being a very stable and responsible person. And I am so glad to see that. I think this agreement is appropriate. You're doing what you need to do. Quite honestly, it's above and beyond what you would do. So I think that is great. What I am going to do here is I'm accepting the deferred judgment of conviction, but not as it's written. I'm amending it on the record for the parties to know. What I am going to do is I am cutting it from 12 months to 6 months duration. You've earned it.
Thank you.
You're doing all of the great things. You're being a great mom. You're being responsible. You are taking care of yourself. You're taking control of your life. You're looking for a better future, and you're bettering yourself for your children as well as for yourself. You deserve to have a benefit. And so this will only remain in effect for 6 months. Another thing that I'm going to do, you have $250 posted. I am going to direct the clerk to transfer $150 from that bail you have posted over to the district attorney's office to pay that $150 fee. So that's another thing off of your plate. The only thing that you are going to be responsible for doing now is to stay out of trouble. Don't hang with anybody you shouldn't. Don't do the things that rise to the level of probable cause for a crime, and remain sober. And then in 6 months, bam, it's off your record.
Wham,
Thank
bam.
you.
All done.
All right. Keep up the good work. Again, I am so proud of you.
That's awesome.
Anything else that, go ahead.
Sorry, that was my daughter. Babe, get out of here.
Okay, that's okay. Anything else from either council?
Not for me, Your Honor.
No, Your
Well,
Honor. thank you.
hello. What's your name?
Joyce.
Joyce?
Yeah.
Well, you are a beautiful little girl. Be proud of mama. All right. Thank you so much. Keep up the good work.
Thank you. Let go of the cat, babe. You're choking.
You're choking the cat. Let go of the cat. Okay. We're going to bail. We're going to jump up to Thurston County, Washington, which is in progress right now.
I have a criminal calendar this afternoon, and criminal calendars take precedence over our civil calendars. So we'll conclude all our small claim activity at noon. There's no way we're getting through 5 cases. I'd be shocked. I'd be shocked, frankly, if we got through 4.
I'd be shocked if we get through 2.
Maybe optimistically, we could get through 3. And this is really dependent on whether the parties can get right to the issue. They don't need to tell me their life story and go through all the other non-related issues involving the relationship. So optimistically, we could potentially get through 3 cases, 3 of the 5 that are settled. So, or that are currently scheduled. What does that mean for you? Well, if you're not one of the 3 that goes, or one of the 2, one of the 3, however many we get to, then what happens is you get rescheduled. You get rescheduled to come back on another small claims day, and it won't be next Friday. Probably won't be the Friday after that. It'll be somewhere down the road where we have enough room on the calendar to put you back in there, and you'll go through this process all over again. Now, if that prospect turns you off and you say, I don't want any part of this, and you depart, if you are the defendant and you're not here when I call your case, I will award default judgment to the plaintiff. If you're the plaintiff and you're not here when I call your case, I will dismiss your case. The only exception is if you settle your case. If you settle your case, all you need to do is notify us that you've done so, and you will then be free to leave.
This is Thurston
Now,
County, Washington.
We're going to
They have some
do a couple
bangers out
things
there.
to assist you in your efforts to attempt to negotiate
Forced
the problem that
mediation,
has
for
you
one.
here today, and see if the two of you can come up with a solution to the problem. First of all, we have with us Marnie. Good morning.
Good morning, Your Honor.
Let's see, we have one, two, three mediators from Thurston County Dispute Resolution Center. These folks are experts in mediation and negotiation, and they donate their time to come into small claims court to assist all of you in your efforts to attempt to resolve the case that finds you here.
I'm not sure if they're experts. They're definitely professionals.
And I strongly urge you to take advantage of the service that they're going to offer you. Now, maybe the two of you have tried to figure out a way to settle the problem that would meet both of your needs, and you've just been unable to do so. You just haven't been able to come up with a solution to the problem. Or maybe the two of you just have a difficult time communicating with one another, and for whatever reason, you find yourself here and you just said, well, I'll see you in court because we can't come up with any solution. I will suggest to you that no matter which of those approaches describes your experience, that you put that aside and make a good effort today with the assistance of a mediator to attempt to come up with a solution that meets the needs of both of you. So in that first case where maybe you've tried it and you've just been unsuccessful, and it may be because you're so closely tied to the problem you can't see the forest for the trees, you may find it very helpful to have an objective, neutral third party listen to the two of you and perhaps suggest a new way of looking at the problem that the two of you haven't come up with. Also, if the problem is the opposite, that is two of you just have a difficult time communicating with one another for whatever reason, you may find it very helpful to have this person listen to the two of you and open up some lines of communication that are not now open. And you may be pleasantly surprised. If communication actually occurs, there may in fact be a way to settle the case without going to trial. And the last pitch I would make is, I truly believe after many years of doing this, that you would be much more satisfied with the resolution that you and the other party come to an agreement on than one that's imposed by me. So I really urge you to take advantage of the opportunity we're going to give you today to attempt to settle your case. Now,
she's not going to be.
We have a couple of cases where both parties are present, or we have a couple of cases where there's one party present. So Mr. Bonpasuth and Ms. Romanello, just remain where you are, and I'll be chatting with you shortly. The other cases, what we're going to do is put you into breakout rooms. All our mediators are remote. So for those folks in the courtroom, we'll figure we have one room set up with a tablet, and you'll be speaking with a mediator from that room. For those people who are remote, you'll have each individual will be going into a breakout room with a mediator. We can only do 3 cases at one time because we only have 3 mediators. So the other 2 cases, you can begin speaking to one another, or you can just wait for a mediator to appear. They will move on to the other remaining case.
Hello? Hello?
Yes, hi, good day, sir. Mr. Dwayne, this is Anaya, and I'm calling you from the Great Vacations. How are you doing today?
Pretty good.
Oh, great. Sir, I'm calling because it shows that a few years back, you purchased a travel package with insurance, but it also shows that you never traveled. Did you forget about it, or did life just get in the way?
That was the travel package with the medical insurance, right?
No, sir. It was a travel vacation package. And, sir, let me just go over a few
Yeah, it was
a few
vacation,
details here.
but it was a vacation, and it had medical insurance for while you're on the vacation. Like if you get sick on the cruise, they have a doctor and things like that, right? Was that the one?
Mm-hmm. Mm-hmm.
Okay.
All right. So, sir, let me just go over a few details here. So, Let me start with a 4-day and 3-night host stay in Las Vegas, where you can stay on or off the strip, and the choice is yours. We are also including an 8
I
days
wanted to
and
be
7
off the
nights
street.
strip,
It's
sir,
just
strip.
oh the strip. I'm sorry. I thought you had to stay on the street. I don't like the street very much. It's noise.
Yeah,
There's
yeah,
trash everywhere.
yeah. Sir, we are also including an 8 days and 7 nights all exclusive cruise with the choice of Carnival, Norwegian, or Royal Caribbean.
Will they
So
have a
it's all
doctor on board for
inclusive.
those? I'm
Yes,
super
sir.
worried about getting sick on a cruise. You've heard the stories about people where like everyone gets sick.
Mm-hmm.
I
Yeah.
want to go on the cruise, but I want there to be like medical in case like the food's bad or something.
Yes, we have that one, sir, in our cruise. And sir, it's all exclusive, so all of your food and drinks are covered. And also you have here a 5-day and 4-night vacation where you can choose from 25 major cities, and it comes with 3 round trip airline tickets. So this package is good for up to 4 travelers.
Could I get
And
like a free like a medical checkup before I go on that one? Just to make sure I'm not bringing any viruses on the trip?
mm-hmm. Sir, I will just connect you to my promotion manager because I don't want to mislead you. So he's the one to assist you further about the travel vacation package that you have,
Has he been
and
vaccinated?
you can, sir.
Has he been vaccinated? I'm just super health conscious.
All right, sir. So please just stay on the line for a moment.
Okay.
Hello, Dwayne.
Hello.
Hey, Dwayne. My name is Erica, and I am the promotional director here, and I will be the one further assisting you. How was my representative? Were they kind, courteous, and polite?
Yeah, I was trying to get. I had placed an order for a cruise, or I had booked a cruise, but it was supposed to have medical insurance involved. I never took that one, and she said that that's what she's calling about. And then she said something about I had to stay on the street in Las Vegas, and I'm not sure about that part. I don't like germs, and the street in Las Vegas is there's lots of people there. Is there any other options?
The street?
She said I had to stay on the street, on or off the street in Las Vegas.
The strip, you mean?
Oh, I misheard. Okay, here, it might have been an accent thing. That's how that, I'm sorry. Now I'm embarrassed. Okay, go on. Okay, where were we? We were watching court. Sorry, I got a prank call. I had to interrupt court for that. So let's see what's
And
back to the small
looks like number
claims.
4 in a breakout room. We have Olympia Auto Sales here, but Mr. Vargo remote, so we're going to need that room after. So let's have them be the next ones to get a room.
How is that lady's
Okay.
China hutch not falling over?
All right, so if you're remote, you get an invitation to a breakout room. Please accept it. And you'll be there with the other party and the mediator.
Elrod,
And if you are unsuccessful in mediation, you'll
this
get
right here,
yourselves back into the
which is a
courtroom and
ATEM switcher.
we'll
It's a hardware switcher.
potentially be going to trial on your case. And let's see. Right.
I just knocked my camera.
Okay.
Scowampus. Okay. Is that straight? Ish. Exposure comp. What did I just do?
Okay. All right. Thank
Wait,
you.
I use
All right. So
I use a hardware
for
switcher.
Olympia Auto Sales, 3 of you here. Sorry to take up everybody's time today. It's probably going to be my guess that, if you want to go get some fresh air or something for about 15, 20 minutes, you can come back in here. We'll see where we are as far as having another room available. If you're in the general area, we can find you because the other rooms are being used by attorneys in the criminal cases, but sometimes they open up, and if we can get one, we'll use it. So we'll come find you. And the two folks back in the courtroom, we'll have somebody come get you in a moment to take you into that room. And who else do we have in the courtroom? Sir, your name is?
Cease.
Okay.
I think that's a great idea, Josh. Quick lunch
Ms. Hauger? Yeah, okay, two of you are here. So you're also going to be in line for that room. So you're welcome to walk around. It's going to be a little bit before the room's available.
Excuse me, we've already been to mediation.
Okay, you're going to go again.
It didn't take. You have to try again.
All right, so sit tight, folks, and we'll get this going as soon as we can get it. Is Justin coming over?
Let me just tell you, this judge hates this part of his job. He hates it with a passion. That's why he does a lengthy intro. He does not want it to be successful. He does not want to have to hear everyone's arguments. He wants everyone to just talk to each other and work this out on their own. And if they can't do it on their own, then to have it work out through mediation and just be done. He hates the back and forth bickering, him having to sort it out with the children. Anyway, good stuff.
So let's see, that would be Ms. Heiser and Ms. Duncan. If you'll step out with Justin, please. Yes.
Okay. Are they okay then? Everything's perfect.
I'm going to call this drama court. That's what we're going to call it. We're going to do a quick break. We'll come back and watch this. You only get till 1 o'clock.
Let me know when it starts to happen here.
Let me know when it starts popping, says the judge. 1 o'clock is the start. So quick break. We'll be back. I don't use OBS, by the way. Those who asked, I don't use OBS. I use this switcher, which has it's hardware. So all my HDMI sources plug straight into that, and I can push buttons and change what's on the screen. I also have a Stream Deck XL that has 85 pages of buttons that allow me to manipulate everything from the color, the lighting, the position, the overlays, images, you name it. I can control that as well, and I can control it through my computer. So 3 different ways to do it, and I'm a big fan of hardware over software. OBS is just, it eats up the processor on the GPU, the graphics card. It's very intensive, makes it hard to do things on your computer and also run OBS. So, and I think it's more reliable. So OBS, not a sponsor. All right, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again in about 15 minutes. I do have all the buttons. I have 1,178 or so, I think was the last count, buttons. Lots of buttons. But we'll be back. We'll be back with the Thurston County Drama Court, also known as Small Claims, and we'll bring all. No, Winamp? Oh man, Winamp was the bomb. My first DJ job I ran on Winamp with a whole bunch of MP3s that somebody had just downloaded for me. So, good stuff. 15 minutes? I think 15 minutes. That's it. It's quick. It's quick. I don't know when they're going to start. We don't want to miss a minute. So, we'll see you guys in a little bit. Grab some lunch, run to the bathroom, come back. We're in for a little bit more this afternoon. And then Kouri Richins on Monday. I'm excited. See you guys. Wait, I forgot to build the portal. Don't go anywhere. Hold, please. I built the live stream, but not the portal. Hang on. Customization, redirect, add, save. Okay, portal.
Hello.
-1. I lose 1 point for that.
What more do you need to see?
There you go. See you guys in a bit.